Yes.
May I plead, Your Lordship? Your Lordship, I beg to mention item number 29. This matter may be listed after 2 weeks or 3 weeks, Your Lordship.
Yes, have you informed the other side?
Yes, Your Lordship, I've informed the AG.
29. List of the
Obliged, Your Lordship.
May I, Lordship?
Yes.
Lordship, I beg to mention item number 3 and 4, Lordship. Leading counseling out of station due to the health issue, Lordship.
3 and 4.
After 3 weeks, Lordship.
Huh?
After 3 weeks, Lordship.
Lordship, there is interim order.
Huh?
There is interim order. That may be continued.
On the prayer of the learned counsel for the petitioner or respondent?
And for petitioner, Lordship.
Petitioner.
Lordship.
Matter stands adjourned. Interim order. Matter stands adjourned for 3 weeks. Interim order pass earlier. Shall continue till then.
Obliged, Lordship.
May I make mention, my lord? My lord, this is DB matter. I think tomorrow we'll be having DB matter. This is criminal matter, my lord. Let this matter be heard tomorrow.
Hard means for final hearing.
Final hearing.
Huh?
Final hearing.
Final hearing, you will have to bring it to orders. We'll have to see.
The paper book is also ready. Everything is ready, my lord.
Tomorrow, we see you make a mention tomorrow for Thursday. We'll see because we will fix some other matters for hearing. May not be possible hearing more than 2 criminal matters.
In that case, let the matter be heard day after tomorrow.
Day after tomorrow, we'll see. We'll verify. We'll verify whether DB is there. Otherwise, on Thursday.
All right.
We'll see how many matters are fixed hearing matters.
Obliged, matter.
May I, Lordship? I beg to mention item number 15 on behalf of JGNA.
Item number
15 is out of station. I have informed the other parties already.
why this method is listed? Orders method.
This is a
Maybe for steps, something like okay. On the prayer of the learned counsel for the petitioner, matter stands adjourned for 3 weeks.
2 weeks, Your Lord.
Huh?
2 weeks.
2 weeks.
Yeah. Obliged.
My lord, I beg to mention item number 30.
1330.
30.
Okay.
May it kindly be listed.
Okay.
Yeah, after 3 weeks.
After 3 weeks.
May I please, Lordship? Lordship, I beg to mention item number 13 and 28, Lordship.
13 and
28, Lordship. Here, Lordship, we have to file affidavit of opposition, Lordship. We are waiting instruction from the department, Lordship.
13 and
28, Lordship.
28. You are for the respondent.
Respondent, Lordship.
You want to file an affidavit in opposition.
Yes, Lordship.
The learned counsel for the respondent number.
Respondent number 2 and 3, Lordship.
Respondent number 2 and 3. Praise for and is granted 3 weeks.
3 weeks, Lordship.
3 weeks time to file counter affidavit.
Deeply office.
My Lordship.
Yes.
Lordship, I would like to mention item number 25, Lordship. Matter may be list of the 3 weeks, Lordship. Respondent number 4 has already filed affidavit, Lordship.
You are for a petitioner?
Yes, Lordship. Government
Now-
had to file affidavit, Lordship.
Huh? Government is yet to file affidavit. You want time?
Yes.
The learned government counsel submits that he may be granted some time to file affidavit on behalf of the government. Accordingly, 3 weeks time is granted. List after 3 weeks. 25.
Lordship.
Yes.
My Lordship, I would also like to mention item 16 and 20, Lordship.
16 and
20, Lordship.
20. Not
Matter may be list after 3 weeks, Lordship. Mr. Kato is out of his station, Lordship.
Okay.
DSGI.
Okay. On the prayer of the DSGI, matter stands adjourned for 3 weeks. Yes.
May Lordship. Lordship, I beg to mention item number 22 and 23, Lordship.
22 and 23.
Lordship.
Titara.
Matter may be fixed on 15, Lordship.
Yes. What to do? He's having some perspective. On the prayer of the learned counsel for the applicant in IA. Huh?
Lordship.
Right in IA. Applicant, matter stands adjourned for 3 weeks.
Lordship, matter may be fixed on 15, Lordship.
All his matters are adjourned for 3 weeks. All his matters are adjourned for 3 weeks. Now what to do?
Lordship, it's transfer posting
Okay,
matter.
on
15th, Lordship.
the day after tomorrow.
Yeah, Lordship.
Urgencies are different for different cases. Okay, on 15th.
Obliged, Lordship.
Interim order pass earlier.
My pleasure, Lordship.
Yes,
I beg to mention item 10.
item 10
Yes, Lordship. Lordship, can it be taken up next week, Lordship?
next week.
Some difficulty, Lordship.
Okay, on the prayer of the petitioner, the matter stands adjourned and be listed.
Next week, Lordship. Oh,
Yes, sir.
Anything survives?
No, my lord.
Huh?
No.
Nothing survives. Okay. The learned counsel for the petitioner submits that this petition has become infructuous. Accordingly, this petition stands closed to being infructuous.
Obliged.
My lord.
Yes.
My lord, this matter already listed on 2 occasions for motion, my lord.
But not to occasion.
Yes, on 2.
What is the judgment reserved in connected matters?
Item number 7.
Huh?
Item number 7, my lord.
10 is adjourned, isn't it?
Here, my lord, there is no connected matter, my lord.
But there is a order on 610 that as the judgment has been reserved in connected matters, list this matter again after ensuing puja vacation.
My lord, this connected matter is for members, my lord. Connected matters is for members, my lord. My lord, I am challenging appointment of chairman, my lord.
What is this matter relates to?
This matter, my lord, I am challenging appointment of respondent number 6 as chairman and press advertisement, my lord. My lord,
This is the matter related to Mr. Chaudhary, APSC.
yes, my lord.
It's connected to item 18, Ali, it was in that.
Till there. So another petition is there. Will hear along with item number 7 and
My lord, here I am challenging press advertisement, my lord.
there that is also challenged in the other petition.
Yes, it is under challenge.
8 and 9. We'll take up with 8 and 9. We are taking up a final disclosure. Be ready.
What is the position, sir?
This is item number 2. Okay, we'll take it up this APSC matters.
He was a selected person.
All right.
Be there. Okay.
May I say, my lord?
Hmm.
I am for responding. I am praying some more time, my lord, for
Okay.
epidemic
You have
process.
respondent number
2 to 5, my lord.
2 to 5.
2 to 5.
Uh,
2, 3, 4, and 5.
Learned counsel for the respondent number 2 to 5. Praise for and is granted 3 weeks time to file counter affidavit.
Obviously.
List accordingly. Yes,
May I, Your Lordship? Your Lordship, in this case, Your Lordship, I was supposed to file a rejoinder.
rejoinder.
Yes, Your Lordship.
You want some more time?
Yes, Your Lordship.
Okay, the learned counsel for the petitioner seeks further
Your Lordship, 3 weeks.
3 weeks time to file rejoinder affidavit. Prayer is allowed. List accordingly.
Much obliged.
No, we'll take it after other matters. It will not take much time. Most of the matters are actually. 2, 8, 9 will take together. Yes. You have got a respondent.
Yes, my lord. On behalf of M. Tata, Union of India.
Yes.
My lord,
due to some
personal difficulties, he is out of
Okay.
state.
It is on the prayer of the learned DSGI. The matter stands adjourned to enable the Union of India to file affidavit in opposition. List accordingly. Adjourned for 3 weeks. Huh? List accordingly.
Wait, please.
Yes.
My lord, though my name appears, my lord, this matter is being conducted by one of my colleagues. Can it be taken up next week?
Some other day.
Some other.
Okay. And the prayer of the learned counsel for the petitioner. Matter stands adjourned and be listed
Next week.
next week.
Okay.
May I, Lordship?
Yes. Respond number 5. Yes, respondent number 5, what to do?
I'm the
Tell us.
petitioner.
Huh?
I'm the petitioner.
You are the petitioner, we know that, but what about respondent number 5?
No,
You are not aware regarding respondent number 5. Respondent number 5, notice service report is still awaited. Since the month of July 2022. You take fresh steps.
We have already taken a step.
We have already taken steps. You take a steps, fresh steps. Okay. In view of office note dated 10/11/2023, the learned counsel for the petitioner prays for and is granted 10 days time to take fresh steps upon respondent number 5 by registered post as well as by usual mode. Steps be taken accordingly. Notice is made returnable after 4 weeks. Take fresh steps. Yes.
My lord, I am appearing on behalf of K. Gara, counsel for the petitioner. My lord, I may be allow some more time to find
How much time?
maybe 4 weeks, my lord.
Okay. On the prayer of the learned counsel for the petitioner, further 4 weeks time is granted to file the rejoinder. Full stop. List up accordingly.
All right, my lord.
Yes.
May I, Your Lordship? Your Lordship, in this case, Your Lordship,
Respondent number 3 and 4. You are for the petitioner.
yes, Your Lordship.
Though the learned counsel for the petitioner is present, none appears for respondent number 3 and 4, who were supposed to file additional affidavit. Full stop. No additional affidavit has also been filed. That being the position, matter be listed in the admission column next week. We
Much
argue on
obliged.
next week.
Yes.
I don't know, I'm praying for some more time to file the affidavit, my lord, regarding that.
Affidavit
Yes.
with as regards Dusty.
Yeah, ma'am.
Okay. The learned counsel for the petitioner prays for weeks' time to file affidavit on service upon respondent number 5 through Dusty. If the prayer is allowed, please take accordingly.
There's an interim order.
Interim order passed earlier shall continue till the next date of listing.
21, my lord, I have received the copy of the affidavit filed by the respondent, but I seek 3 weeks time to.
Okay. The learned counsel for the petitioner prays for and is granted 6 weeks time to file the reply affidavit to the affidavit in opposition filed by respondent number 6. List accordingly.
My lord, here affidavit has not been filed.
Okay, here not filed. Yes. Who will file state?
Yes, Your Lordship. Your Lordship, at least 3 weeks time may be given, Your
Okay.
Lordship.
The learned state council prays for and is granted 3 weeks further time to file counter affidavit. Full stop. List accordingly. 2060. Yes.
My Lordship,
Yes.
Lordship, affidavit against not filed, counter affidavit not filed. Lordship.
You want to, yes, who will file counter?
Lordship, I'm for respondent number 4 and 5.
Okay,
Lordship, we may allow 2 weeks of time
okay.
to file counter.
The learned counsel for the respondent number 4 and 5 prays for and is granted 2 weeks time to file counter affidavit.
Lordship, there is an interim order.
List accordingly. Interim order passed earlier shall continue in the meantime.
Obliged.
Deeply obliged.
My lord, I am appearing on behalf of C. Modi, my lord,
Okay.
counsel for the petitioners.
Hmm. What to do? Respondent number 3 and 4 notice is returned back unserved. So you'll have to pass some order. Either you'll take fresh steps. Or
My lord, interim may be continue.
interim will the next stage. First stage is what will you do regarding respondent number 3 and 4? Notice is reserved, returned unserved. You are for?
Lordship,
Five.
for the respondent, but Lordship, they are like punish us extra.
Okay, for the time being, you obtain your instruction. But what about respondent number 3, 4, and 5? 5 notice is still awaited. What about 3 and 4? What will you do? Unserved notice returned. The learned counsel for the petitioner submits that in view of office note dated 10/11/2023, he may be permitted to take fresh steps upon respondent number 3 and 4. Full stop. Prayer is allowed. Accordingly, steps upon respondent number 3 and 4 will be taken within a period of 5 days from today.
5 weeks.
5 days from today. Notice is made returnable after 4 weeks. In the meantime, service report in respect of respondent number 5 may be awaited.
Lordship, they may be directed to punish us extra copies also.
Okay.
They haven't.
It is submitted by the learned state council that no extra copies has been furnished to the state council.
Yes.
Full stop. The petitioner in reply to such submission, the petitioner assures this court that extra copies shall be served within a period of 5 days from today to the learned state council.
Period of 2 days, lordship, because this was filed in the
Okay,
month
period
of
of
June,
2 days, 2 weeks. Okay. List accordingly.
My lord,
Interim order passed earlier shall continue till the next date of listing, subject to furnishing of copy to the learned
Yes,
state council within a period of 2 days.
right, my lord.
much applied.
Yes, what is this? Yes, is not there.
Yes,
Okay.
my lord, I am for the respondent on
Okay.
behalf of M. Khato.
Okay. It is submitted that Mr. M. Kato Lanet ASG is having some personal difficulty today. Accordingly, a prayer for adjournment on his behalf is made. Full stop. Prayer is allowed. List this matter
3 weeks.
after 3 weeks. Yes. Now, Mr. Term for Mr. Chaudhary.
Mr. Mazumdar.
Mozumdar.
There was sudden disruption, possibly
7, 8, 9. Item 2 আহিব ঠিক আছে এই ৰিটাৰ্ণ কৰি দিছো বান্ডল লেটাৰ বুলি কয় সাৰ্টিফিকেট মই আৰ্গুমেন্ট কেতি মোক দিম মই তাত নোট কৰিম এই মই চিম্বল কম বুঝিম আরে নোট তো আছে রেকর্ড একটা অপরচুনিটি হলো একটা ব্রিফ হয়ে গেছে
may be your
just a minute, just a minute. Yes.
So far as the facts of the case are concerned, my lord, I need
Similar.
not, similar.
Except additional fact that you resigned from your earlier job.
Exactly, my lord. And only the relevant portions of certain documents, including the advertisement and certain pleadings which are peculiar to this case, I will show. Otherwise, detailed facts I not argue. Your lordship is already heard. This one court is aware of the facts. Basically, it's a question as to whether the order in recalling the order of appointment by the government is constitutionally valid.
Whether you have already acquired a right.
Yes.
To be terminated.
Exactly.
They are having the right to terminate.
Yes.
But whether you have acquired a right to be terminated under
317. That is what.
Or they can just show you the way they have done.
Yes. And my lord, my second leg of argument will be even if they can, then they have to comply with the basic requirements of Article 14, which according to us, they have not. This is my second argument.
Yes.
My lord, I shall take your lordship first to the advertisement. Page 20 of my petition. Because the Supreme Court has made it clear there is no qualification laid down for this. But there are certain criteria. A person cannot, from the street cannot be picked up for this officeman. That is there in the Supreme Court judgment. Page 20, the advertisement manner. Lordship has seen in the middle eligibility criteria. Persons with
page 20 of WPC
of the petition WPC 223, manner.
Okay. WPC 336. 223.
Page 20, man.
Just a minute. Page 20.
Yes. My lord, just below first paragraph, my lord. Chairman, APPSC, 1 number, member, APPSC, 3 numbers, then eligibility criteria. Persons with outstanding career, outstanding academic excellence, and capacity to judge independently suitability of candidates for a civil post service under the government of Arunachal Pradesh. He or she shall not be a member of parliament or a member of legislature of any state or union territory or hold any other office of profit or connected with any political party. This is one part. And then page 21, last but one paragraph, integrity, character, and antecedents. The integrity of the candidates shall be beyond doubt. They shall be free from all types of criminal and other charges. However, the appointment of the selected candidate shall be subject to verification of character and antecedents by the police. This is the requirement under the advertisement. Next. But at this stage, I'll just trouble the court with Article 316 for a moment. I'll be very specific in law so that I take minimum of time.
No, we have enough time. No.
He is in more of a hurry.
I was thinking that I have confidence in him that he will not disclose it in the court.
He is in hurry.
That much confidence I developed yesterday more. So when we traveled together, my lord, after the cancellation of flight.
Don't trust him.
Yes, it appears, my lord. Friends are not always friends. Well, Article 316. I'm just showing this for the purpose of showing that what is my position vis-a-vis the requirement under the law for this much, for minimum requirement. Appointment and term of office of members. The chairman and other members of Public Service Commission shall be appointed in case of the Union Commission or Joint Commission by the President, and in case of State Commission by the Governor of the state, provided that as nearly as maybe one half of this. These are all other things, my lord. No qualification as such is mentioned. Now 317, my lord, I'll come later on. So this is the position, my lord. With this background, my lord, when I applied, I need to point out to your lordship what is the petitioner, what is his background, what is his integrity, etc. For that matter, we have annexed the biodata, and lordship may kindly turn to page 24. My copy is slightly blurred. I don't know what is your lordship's copy, my lord. Page 24 is my biodata, my lord. Just a minute. First page is slightly blurred, my lord. Lordship will kindly see serial number 7. Educational, professional qualification. His matriculation CBSE 1983, 77.46%. Then class 12, joined National Academy through UPSC exam and Service Selection Board after class 11. Then graduation JNU 1987, FGPA 4.72. Then PG, Madras University, 2003, 69.30%. Then MSc in Counseling Psychology. Right inside column, CGPA 3.34. Then other qualifications. 3 years joint training in National Defence Academy, Pune, 1986-87. 1 year military training in Indian Military Academy, Dehradun, 1986. Then 6 months young officers course at infantry school. Commando course, security course, attended counter-insurgency and jungle warfare course, etc. Mizoram. Underwent junior command course 1999. Passed defense service staff college competitive examination and underwent one year course at defense service staff college Wellington. Present occupation re-employed after retirement at ad hoc station headquarters Teju. Brief service particulars also we have given, my lord. Yeah, it's for the lords. And from this page, my lord, the bottom of this page, also kindly see from 2006 onwards, commanded Assam Rifles Battalion in counterinsurgency opposition so Then during the period, also successfully conducted a recruitment rally for enrollment of soldiers at the following places as presiding officers: Delhi Police Training School in 2007, Bikaner, Rajasthan in 2008, as the Deputy Brigade Commander successfully conducted joint training with French Army and Nepal Army in Chowbalia, Uttarakhand. Part of pre-course as directing staff to prepare Indian Army officers for Defence Service Staff course exam at Hisar, Haryana in 2011, prepared question bank for Defence Service College competitive examination. And all this probably I should not read, Your Lordship will kindly consider. Then next page, page 27, Lordship kindly see, under academics I have given how I have done. Won first prize in English essay, won book prize for obtaining the highest marks in geophysics and international studies, acquired first class MSc degrees in defense and strategic studies, then scores first in cross county race, best athlete, medals in cross county, third among Indian Army officers in battle physical efficiency test during the defense service staff college, etc. Then professional also I have given 1, 2, 3, 4, 5. So with all this background, I have applied for this post of member, Arunachal Pradesh Public Service Commission. Then as far as
Yes.
Now, as far as the procedure adopted by them is concerned, a screening committee is there. Screening committee considers everything, then recommends it to the government. Page 29A, Lordship will kindly see the reconstitution of the by amending the screening committee. They have reconstituted with retired IS officer, then Chief Secretary of Government of AP, then Vice Chancellor of Nehu, Shillong, page 29A. And thereafter, page 30. And this appointment was preceded by an approval from the cabinet of the government of Arunachal Pradesh. Page 50. 4th of February it was held and cabinet approved my appointment. Page 50 is the order of appointment in exercise of powers conferred.
Page 30.
I'm sorry, man, 30. Slightly, page 30. Appointment order. In exercise of powers conferred under clause 1 of Article 316 of the Constitution of India, read with clause 4 of the Arunachal Pradesh Public Service Commission Regulation 1980, Government of Arunachal Pradesh is pleased to appoint Colonel Postari retired as member Arunachal Pradesh Public Service Commission. The pay and allowances of the post shall be governed by clause 6 of the Arunachal Pradesh Public Service Commission Regulation 1988 as amended from time to time with effect from the date he assumes the charge of office. He shall hold office for a term of 6 years from the date on which he enters upon the office or till he attains the age of 62 years, whichever is earlier in terms of provisions of clause 2 of Article 316 of the Constitution of India. This was the appointment. Then, my lord, page 31, I have annexed the document by which I am showing that I was, after my retirement, I was re-employed. And from there, I have taken a premature release by offering my resignation. Page 32 is also the similar order. And then page 33 is the intimation rather to me by the Joint Secretary to the Government of Arunachal Pradesh that with reference to above mentioned subject, it is to inform you that, page 33, I'm reading, my lord, that the Honorable Governor of Arunachal Pradesh has consented to administer the oath of office and oath of secrecy to the newly appointed chairman and members of the Arunachal Pradesh Public Service Commission on 17th of February 2023 at 1500 hours at Darbar Hall, Raj Bhavan, Itanagar. In view of the above, you are requested to kindly arrive at Raj Bhavan, Itanagar by so and so, along with your family members, for taking oath of office and oath of secrecy as member of the Public Service Commission. Date of swearing, my lord, in the first part of the day when I was informed verbally over phone that the oath taking ceremony is deferred. And on 18th of April at page 35 is the order by which the appointment was recalled. In public interest, the governor of Arunachal Pradesh is pleased to recall the government notification number so dated 7/2/2023, appointing Colonel Post Tari retired as member Arunachal Pradesh Public Service Commission with immediate effect. And thereafter, my lord, page 36, a fresh advertisement was floated, inviting fresh applications for these posts. And in the new advertisement also, criteria is same. And the criteria mentioned in the new advertisement are all same except the requirement of declaration of property.
Where is that?
Where is that? Clause E, page 37, madam. Applicants shall also submit declaration of properties in the prescribed form placed as Annexure B along with the application. Other than this, my lord, clause D above this and page 36, serial number 1, eligibility criteria are same.
Where is the withdrawal?
Recall order, my lord.
Recall order.
Page 35, my lord.
Okay, 35.
My lord, by the writ petition, my lord, we are challenging this order primarily on the ground that once a person is appointed under 316, Article 316, the only way to remove that person is under Article 317.
Yes.
And 317, my lord, specifically says that only in the event of, on the ground of misbehavior and after Supreme Court reference, etc., the procedure prescribed, a person can be removed. Admittedly, 317 was not taken recourse to. There is no dispute. Now, in the writ petition, my lord, we challenge this.
According to them, that protection until and unless the swearing in is not
takes place,
that they are not entitled. So admittedly, they have not opted for that.
Yes.
Because in their interpretation of 316,
yes,
it is not required.
Yes.
So therefore, there is, even if it is required, they have admitted
yes,
that we have not
done
no
it.
requirement. So therefore, 317 particulars is not required.
Not required.
Here,
yes.
My issue is whether you have a right is accrued. According to them, no right is accrued after 316 only, because there is a second stage of swearing in terms of a rule frame under 318.
Yes.
And until and unless swearing in is taken place, then you cannot be treated as a member. And the moment you cannot be treated as a member under 316, 317 is not applicable.
Yes, there is the argument. And for this, my first submission will be, if your lordship goes to the regulation to put us here, regulation. If the appointment, I'm just showing from the appointment letter, my lord. My submission in response to this will be, my lord, appointment under Article 316 is complete in all respects, and oath of office and administration of oath of secrecy are only consequential, and in the absence of oath, the appointment under Article 316 will not remain inquate, that is incomplete. As a result, the a reply by them that since oath has not been administered, he has not acquired any title to hold the office of that, will not be acceptable in my humble submission. And that
you
I'm
will say
submitting-
that notification issued is under 316.
6. Once it is issued, the appointment is complete in all respects. Oath of office is not something in the absence of which the appointment will not be complete. Their argument is appointment, although appointment has been made, unless oath of office is administered, it is not complete and you have not acquired any right.
That is it.
My submission is, my lord, once an appointment is made under 316, there is no other formalities required to make the appointment complete. And if you want to remove the, and secondly, my lord, if the appointment is to be withdrawn, the only procedure prescribed under the Constitution is Article 317. There is no other. Recall is a thing which is not, which is unknown to the Constitution, and it is not permissible. The only permissible way is removal. My lord, my second leg of submission in this regard is the argument possibly is that oath of office is required, number one, to enable you to enter into the office. Number two, possibly they have argued, because on the last question they argued, they are also saying that, see, look at your appointment itself says, appointment itself says, second part, my lord, he shall hold office for a term of 6 years from the date on which he enters upon the office. This is the argument possibly, my lord. Last time they argued, possibly they will argue. He shall hold office for a term of 6 years from the date on which he enters upon the office. And now they are saying he will enter upon the office after oath. And you have not entered office. This is the argument, my lord. Itu put us I don't want to panic in. Oh, yes. And secondly, my lord, it is also argued by the respondent government that in the initial sentence of the appointment says, in exercise of the powers conferred under clause 1 of Article 316, read with clause 4 of the Arunachal Pradesh Public Service Commission. Now, if we go to clause 4 of the regulation, page
35. No, not 35. Appointment notification is?
No, my appointment notification is at page 30. What I am trying to show is, my lord, this regulation.
Clause 4 of the regulation.
Of the affidavit. Page 23 of the affidavit, my lord.
Page 23 of
the affidavit in opposition. Yes. There has been some amendment and they have annexed the amendment itself.
So that amendment is so far relating to the swearing in, provision of swearing in.
Yes.
Amendment is to the provision of swearing in, but
Then
can we have a
clause-
copy of the regulation?
We have.
It is in your page. Whole regulation is there.
Yes, ma'am.
It is at page 46 of Mr. Panning's resolution.
Okay.
Lordship has got, ma'am.
Yes, page 46.
Page 46. Now, clause 4, Lordship may kindly have a look. This comes under the chapter composition, pay and tenure. And this regulation has been apparently framed under Article 318 of the Constitution of India. on top, my lord. It is there. And clause 4 says the commission shall consist of chairman, 2 or more members, as may be determined by the government from time to time, and shall be appointed by the government. This is in consonance with Article 316, nothing extra. This doesn't give any additional facet to the order of appointment, so as to say that that part has not been complied with, so the appointment is incomplete. That cannot be argued, my lord. In fact, my submission before Lordship is, my lord, Article 318, if your Lordship goes to Article 318, this itself very clearly says, this gives power to the government to frame regulation for what, my lord? Power to make regulations as to conditions of service of members and staff of the commission. As a matter of fact, my lord, my submission will be, once the government relies on Article 318 so as to say that it was incomplete, the result will be reverse, that you are accepting that there has been a valid appointment. And once you accept that there is a valid appointment, there is no question of saying that a part of it has not been complied with, so the order is incomplete. This itself says this is a subsequent stage. This is a regulation. 318 itself gives power to the government to frame regulation for what purpose? For regulating the conditions of service of members. Once a person is already a member, in order to regulate his conditions of service, rules are required, regulations are required, and for enabling the government to frame regulation, this is an enabling provision. As a matter of fact, my lord, the rules 4 and the 4A, which has been brought subsequently by way of amendment, page 23 of their affidavit in opposition, Lordship will kindly have a look for a time being, my lord. Page 23 of the affidavit in opposition. Yes. There is an amendment of clause 4A, which speaks about how the oath, what will be the language of the oath, my lord. The regulation may be called Arunachal Pradesh Public Service Commission 9th Amendment Regulation 2015. They shall come into force on the date of publication in the official gazette. In the Arunachal Pradesh Public Service Commission Regulation 1988, after the clause 4, the following shall be inserted. 4A, Governor of Arunachal Pradesh or his nominee shall administer the oath of office to the chairman and members before entering upon their office on the following form, namely, so and so, so and so. Now, this is a provision brought in the regulation. And this is for the purpose of regulating how the oath is to be administered, who will administer, and what will be the language. Well, the Constitution does not envisage that the oath has to be administered on a person who is appointed as a member or chairman of the Public Service Commission. There is nothing in the Constitution. In my humble submission, my lord, this entire exercise of administration of oath, etc., comes in the regulation, and regulation has been framed under 318. 300 speaks about regulation for conditions of service, etc. Since they will be performing a very solemn duty of appointing persons who will select members, that is why it is necessary that they are made to understand that they will have to adhere to the requirements, to the principles, to the object of the Constitution of India. That is why the oath administration has been made requirement under the regulation. Otherwise, under the Constitution, there is nothing that a person appointed as such has to be administered oath of office and oath of secrecy. So that is my reply, my in response to that. As these submissions are in support of my reply to their contention, which they will They have reflected in the affidavit also, that since oath of administration has not been administered on you, you have not entered upon office. And second, I'm sorry, my lord, second part of the appointment order, I'm just showing, there it is mentioned, he shall hold office for a term of 6 years from the date on which he enters upon his office. This is necessary for the purpose of ascertaining as to how long he will work, or till he attains the age of 60 years. This is for the purpose of telling him that, see, you will be working for 6 years from this date, and not for the purpose of showing that, see, unless you take oath, your appointment is incomplete. They cannot say so because Constitution doesn't allow them to say so. That is my submission. That being the position, my lord, the power to recall on the ground that oath has not been administered cannot be exercised in accordance with law. And that exercise of power will be contrary to the scheme of the Constitution, and in view of Article 317, this is absolutely impermissible under the law and unconstitutional. My lord, my second submission is this power to recall, possibly they are also giving indications in the affidavit. Let's say under section 21 of the General Process Act, if an authority has power to do certain things, pass an order, they also have the power simultaneously to withdraw and cancel. I'm just reading section 21 for a moment. Section 21 says like this, man, power to issue, to include, power to add, to amend, vary, or rescind notifications, orders, rules, or bylaws, where by any central act or regulations, a power to issue notifications, orders, rules, or bylaws is conferred, then that power includes a power exercisable in the like manner and subject to like sanctions and conditions to add, to amend, vary, or rescind any notifications, orders, rules, or bylaws so issued. In this regard, my submission will be section 21 cannot be taken resort to for the simple reason that when the Constitution itself provides a manner of appointment and itself provides in Article 317 the manner of removal, section 21 will not come in. And there is one judgment on which I'll be placing reliance to show that section 21 cannot be applied in a situation where the scheme or the act under which the action is taken itself provides the whole scheme as to how this is to be done, how it is to be undone. This is well, shall I go into the decisions, all the decisions together, so that I make my submissions complete first? So that will be my submission. I rely on that judgment. In that case, my lord, a notification was issued for constitution of administrative tribunal of a particular state. Later on, a decision was taken, no. Since the people who will be agreed by any orders to be passed in their service conditions or service matters, they have got remedy under the Article 226. And considering all this L. Chandra Kumar, etc., the Honorable Court said that they have the power to withdraw. Then, in that context, Article 21, Section 21 was interpreted, saying that if the scheme itself provides for undoing the thing, then you have to take resort to that scheme and not Section 21. And in that case, Section 21 was allowed because it was not repugnant to the scheme provided under the Act under which they have taken. So, in our case, my submission will be, it will be repugnant because when 317 says removal in accordance with the procedure prescribed there, and you are doing it by simply an order of recall. So this will be repugnant. Your action is repugnant to the action under 300, provided under 317. That will be my submission. Next is, my lord, now assuming that their argument that oath of administration, oath of office and secrecy had not been administered, accordingly you have not entered into the office, and the appointment was not complete. Accordingly, we have power to recall the order. Assuming that this is correct, assuming that this honorable court accepts this argument, then my second leg of argument will be, even then the order will have to comply with the requirements of Article 14, because every order passed by the government has to be in consonance with the requirement of Article 14 and cannot be an arbitrary and unreasonable order. And I am saying this is arbitrary because I'll show from the facts now that the appointment has been recalled or cancelled on grounds which are absolutely irrelevant to the parameters on which a person is appointed, to the requirement of law under which such an order can be recalled. Now here, Lordship will kindly see, in my humble submission, there can be three reasons on which, assuming they have power, they could recall the order or cancel the appointment. If my lord, I'll show from the facts that just prior to, in fact, the agitation was going on by certain organizations because of the corruptions, etc., in the appointment process earlier. That is an admitted fact. Persons who were agitating were later arrested under preventive detention laws. Now, before my appointment, they submitted a representation on 3/12/2022. And my appointment was on 7/2/23. I'm saying these two dates because my appointment is of a subsequent date and the complaint was of 3rd December 2022. And I'll show from the complaint that the is 3/12/2022.
Appointment.
Appointment is of 7/2/2023, my lord. 7th February 23. Now, this complaint was the whole basis for which the decision to recall the order was taken by the government. This is an admitted fact, madam. Now, I'll take your lordship to the affidavit in opposition filed by them.
Yes.
Page 4, paragraph 8.
Page 4.
Paragraph 8, madam.
Yes.
Paragraph 8 reads like this, my lord. That the statements made in paragraph 12, 13, 14, and 15 of the petition are incorrect, baseless, and misconceived. Further, all Nishi Students Union submitted a letter on 3/12/2022, which contained a 13-point memorandum to the government for consideration. The answering respondent humbly begged to state that, owing to the unprecedented public demand, the Honorable Chief Minister invited all the stakeholders, including the ANSU and PAJSC, for a meeting on 8/2/2023 to discuss the issues raised by the public. In the said meeting, 13 issues raised by ANSU, paragraph 8 of the ANSU earlier were discussed, and the stakeholders were updated with regard to the steps taken by the government thereon. It was inter alia minuted to recall the appointment orders of chairmen, members, and publics placed the matter before the cabinet. It was further mentioned in the minutes to constitute a fresh search committee to conduct fresh selection process. It was further decided that in terms of the suggestion given by the public, a column for declaration of properties of the applicants would be added in the application form. Pursuant thereto, the matter was considered by the cabinet in its meeting held on 29/3/2023, and it was recommended to recall the appointment orders in public interest. Thereafter, the governor was pleased to recall the appointment orders by notification dated 18/4/2023. The answering respondent humbly begged to submit that decision-making process which led to the recall of the appointment orders of the chairman and members of APPSC does not suffer from any illegality and arbitrariness. The positions being primarily repositories of faith and public confidence, the ground of public interest is always available to the governor to cancel or recall the appointments on the aid and advice of the Council of Ministers prior to their assumption of office. It is categorically stated that the appointment process of petitioner was not completed, and hence the action of recalling his appointment does not violate any of
So
his
this
rights.
is the whole case.
This is the whole case. In paragraph 8, my lord, their whole cases reflected.
Nicely.
Nicely written. Credit goes to possibly Mr. Tapin, my lord. He is known for this.
Tapin has summarized in one paragraph. Hope I could have write my judgments like
And
this
some
thought or way.
and some brainstorming probably by my learned friend.
No,
in-
I do not
inside.
think you are here at that point of time. Yeah. Okay.
I had just entered office.
Entered office.
He entered newly, but then he had the whole story in the mind. He saw agitations were going on at that time. On one day, we could not come here because of the agitation. Cases were fixed, we had to cancel our journey. So, my lord, the lordship has seen what is their case. Now, before I make my submission, I'll take your lordship specifically to the complaint what they have written in the complaint. Page 19 of the same affidavit. প্রথম page of importance. Well, page 19, lordship, can you say it is a representation of page 3/12/2022. Nah? Memorandum to the Honorable Chief Minister. I am writing this letter on behalf of Lux Groceries Government, page 19. I am writing this letter on behalf of lakhs of aspirants whose life have been traumatized, shattered, and spoiled due to corrupt practices in the state premier recruiting agency, that is the APPSC. Honorable Chief Minister, sir, as you are also aware of the fact that it is not the first time, but such corrupt practices and anomalies is being reported every now and then in the APPSC. For instance, the official involved, the infamous 2014 paper leak scam gone unpunished. Again, in the year 2017, the state had gone through scandalous episodes when the aspirants on protest against the malpractices in the APPSC were beaten up badly, stripped off, manhandled and tortured by your paramilitary forces instead of redressing their grievances. Ultimately, the helpless aspirants were made to lose the legal battle on the basis of misleading and manufactured SOP of the APPSC. Merit of the case was undermined by your so-called zero-tolerance government. And the saddest part is that neither your government nor the authorities of the APPSC tried to redress the issues properly, left the official free hand by taking mere excuses, because of which a rampant and open selling of question paper was reported this year. No doubt, this time your government tried to act against the official involved in the scam, but not up to the expectation. Hence this memorandum. Honorable Chief Minister, sir, this time we are coming up with the following demands for immediate action. Now, these 1, 2, 3, these are not very relevant. 11 says immediate legislation and implementation of Whistleblower Act, etc. Then 13 is important. The last point, man. Immediate recalling of the 3 officials posted under APPSC. That means persons who were already posted. So as far as the persons manning the commission is concerned, their grievance was with respect to the persons who were already in service, who were already appointed. So far as the present petitioner is concerned, my lord, or for that matter, other petitioner is concerned, against them there is nothing. Absolutely nothing. Zero, my lord. Possibly what they are saying is, see, there are corruptions inside this. You have to rectify that. You have to make legislation. You have to do this, that. But in the meantime, if a process has been started, pursuant to that, if a person has been appointed, against him there is nothing. In fact, my lord, I'll show you, lordship, another document from where it will be clear that against the APP, against the chairman, there is one allegation, that too not on corruption, because of his age, that he has become old. How he will be able to cleanse the organization? This is the only thing. So and this is a complaint of 312. We applied on 9/12. We came much after that. Our application is of 9th of December, 9/12/2022.
Advertisement was?
Advertisement was of 21/11/2022. And I applied on 9th of December 2022.
Advertisement dated?
9th of December 22. I'm sorry, 21/11/22. Advertisement 21/11/22. Application by me 9/12/22. So these statements made in the complaint will clearly reflect that students are very much justified in writing this complaint, because there were allegations, persons were not punished, and this happened in 2014 selection, this happened in 2017. They were within their rights to submit such a complaint, but the question
Now,
is,
how come this post were vacant, your advertisement? It was normal vacancy or earlier persons were removed?
Resigned after that.
But they must resign before 21/11.
Yes, they did.
there is this. There is that.
My lord, issue came to light in September. Thereafter, they resigned.
But
Thereafter
here
they
it says immediate recalling of the 3 officials posted under the APSA.
From the paper.
Officials. In fact, my lord, allegations are there, officials are mainly, not against the members also.
Okay. When they resigned, anything on material on record? These 3 persons?
I don't recall the data.
Okay.
This was-
Okay, anyway.
advertisement was after the release.
So, my lord, it is now very clear that the
Just we wanted to know under what circumstances advertisement was issued.
issued, yes.
How it is fallen vacant
Right,
in
yes.
due course.
I have-
After-
In my application,
You have
they resigned, please.
Okay,
I don't have the-
you take note of that.
My lord, as a result, my lord, my submission will be that I could be removed, provided in my humble submission in 3 circumstances. If I have obtained the appointment by fraud or misrepresentation, all right, nothing is required. It is inherent in the authority who appoints me to remove me. In case of service also, other service also, lordship is in all Supreme Court has said that if the appointment has been obtained by fraud, nothing is required. Even the opportunity of hearing is also not required. If I have obtained the appointment by way of fraud or misrepresentation, they could have recalled. If now they say, no, there was no selection procedure at all for your appointment, then also they could recall. And thirdly, if they say that, see, you are not qualified.
Even resorting to 370.
Even. So in our case, my lord, they are only ground on which they have taken the decision and the cabinet has taken the decision is that there was a complaint. Now complaint says nothing about me. Complaint doesn't say that any of these circumstances have taken place, or I am a person who doesn't have the integrity, which is the main requirement. This is not their case. Their case is that now, my lord, I'll show once again from this paragraph that it was actually, although they said paragraph 8 towards the end, while summing up why they have done it, cabinet has done it, and they say since cabinet has done it, a decision-making process was adopted. Lastly, they say the positions being primarily repositories of faith and public confidence, the ground of public interest is always available. All right. But this is not public interest, it's a public demand. And public demand for what? You have to cleanse the organization, number 1. And number 2, in future, you have to ask for property, etc. Now, yes, my lord, there will always be suggestions to improve the selection process, to include more my lord, criterion, include more criterion in the parameters on the basis of which a person is to be appointed. But for that, a selection which has already been held and a person is appointed cannot be said to be incorrect or my lord, suffering from any vice on the basis of which you can recall it. You see, in future we are seeing that a person who joins this organization as a member, how much of property he has, that also has to be accepted. Very good, you do it in future. But the advertisement will not be invalid on the ground that some more grounds for amendment of, for inclusion of some more criteria, there is a suggestion. On that basis, an advertisement cannot be held to be bad. And the same cabinet earlier approved my appointment. And my lord, just to add one more from my learned friend's writ petition, since the issue is same, page 80 of my learned writ petition is annexed, we could not annex. An extract of the minutes of third.
That we have seen on last occasion.
Yes. So there it says after page 80.
I think we'll go for see the facts from his petition, I think.
Yes,
It's better.
yes. I'm just saying page 80. That there the decision was taken by the cabinet after detailed deliberations. Cabinet considered the proposal of the administrative department regarding filling up of one vacant post of chairman and 3 vacant posts of members of Arunachal Pradesh Public Service Commission. And after detailed deliberations, the cabinet approved. Now, same cabinet is saying today, no, we are recalling. Why? There is a demand. So it was a public demand and not a public interest. This is my submission, ma'am.
Now we are getting this item number. Your is Colonel Postar is item number 7.
WPC 223, my lord.
223. Item number?
Item 8 possibly.
Item 8.
8.
And Mr. Panging's case is item number 7. And somebody else was the item number 2. Your is item number 2. What is the name of your client? Pradip Lingfa. Huh? His name is not there. He is a member or what?
He was a member. He resigned. Now he is saying, he has raised a completely different point. He says that there are no parameters laid down. Exactly what my learned friend submitted. That these are the only parameters in the advertisement.
No, what is his grievance? He has resigned.
He has already resigned. But he is saying that in the advertisement, there are no parameters, objective parameters for selection of the members and chairman. So there should be.
What is his prayer?
His prayer is for setting aside the advertisement and their selection.
And how he is aggrieved?
What is his locus?
Huh?
He is a candidate who has
resigned. You sought an adjournment. Why should he bring this petition here?
That can be dealt with later.
We will deal it later. Or dismiss it right now, today itself. Huh? Okay, we'll pass an order in that case. I thought that he is also one of the selected members earlier.
He has resigned. He is in the earlier group of people who had resigned.
Okay.
And now
what is his locus in challenging the fresh advertisement?
That is one. And he is not even.
You want to participate? Did you participate in the earlier selection procedure? You are not selected. You are not aggrieved by their challenge. Sure. Okay. Okay, we'll take up your petition. They will defer that. I thought that similarly.
Certain issues become very, very important, my lord. Well, that is the position. Position is very simple. Constitution doesn't provide for any power to recall an order of appointment. Once his appointment, they will have to take it to the logical conclusion of administration oath and allow him to enter upon office. The power which has been exercised is not there in the Constitution. That is my submission. And the order, even assuming that they have power to recall because oath was not administered and he has not entered upon office, even then, the order will suffer from arbitrariness and malice in law because the power which they had under Article 318, they have applied for a different purpose from the purpose for which it is provided in the Constitution.
Yes.
Now I'll take a look into the case laws on which I'm placing reliance. Pidabilagasana, 1975 to SCC, page
1975
to SCC, page 649.
649.
Yes.
What is the purpose of this judgment?
That relevant facts were not considered, irrelevant facts were considered.
Okay.
Para 13, my lord. And an executive, while passing an order,
Paragraph.
paragraph 13.
There are some judgments in the file. Is it here?
Possibly it is there because last time we submitted my
1975
to SCC.
No, that is not.
I think we will give you book list. Books are there. Small paragraph. Paragraph 13.
Paragraph 13.
13. The page 659.
Page
659. Lordship has got man.
Yes.
The executive have to reach their decisions by taking into account relevant considerations. They should not refuse to consider relevant matter, nor should they take into account wholly irrelevant or extraneous consideration. They should not misdirect themselves on a point of law. Only such a decision will be lawful. The courts have power to see that executive acts lawfully. It is no answer to the exercise of their power to say that the executive acted bona fide, nor that they have bestowed painstaking consideration. They cannot avoid scrutiny by courts by failing to give reasons. If they give reasons and they are not good reasons, the court can direct them to reconsider the matter in the light of relevant matters. Though the propriety, adequacy, or satisfactory character of those reasons may not be open to judicial scrutiny. Even if the executive considers it inexpedient to exercise their powers, they should stay, and there must be material to show that they have considered all the relevant facts. Now, here your lordship will find the Honorable Supreme Court is saying that merely because you have cited some reason, that will not suffice. Yes, those has to be good reasons. Now, you are saying that there was a complaint. You are saying that there are some suggestions in the complaint. You are saying that there was in the complaint certain irregularities about the functioning of the commission earlier in 2014 and 2017 were there, and on the basis of that complaint I have recalled. Now here in this paragraph I know two things are there. There has to be reasons should be good, and only because you have undertaken some exercise, my lord. In paragraph 18, Lordship will notice, they are saying that we have undertaken a decision-making process. That will not be sufficient because even if you say that we have taken some decision on the basis of a process, that process will not validate a decision which is otherwise invalid. Then one judgment is there of 1992 crimes. For a small one sentence only, I am relying on that one. 1992 crimes.
1992
Crimes.
crimes.
Then within bracket Supreme Court, page 106.
106. I think these are the judgments relied on by the respondents' counsel.
It would be the judgments relied on by me because I relied on many High Court judgments.
Border Liberation Tigers Force, then State of Arunachal Pradesh, then Orissa Administrative Tribunal Bar Association versus Union.
That was given by me, man. I'll rely on that today also.
Okay, for that
For
21.
Section 21, my.
Let me separate it.
Yes.
Okay, this is for you. Then citizenship amendment, this is you.
My land front relied.
Then Constituent Assembly debates. Then 1963 or SCC online Allahabad 172.
No, by should be by.
Then Brahmeswar Prasad 1950 SCC online Patna. Okay. Then 1985 SCC online Kerala. Then Assam Indian Public Service Rule 1978. This is for your purpose. 6th schedule of the Constitutional Amendment. Then Jaginder Kumar, WPC Criminal 9. Code of Criminal Procedure 19. Is it your case? 1994 True Crimes Act 106 SC.
Yes, ma'am.
Yes, this is yours. Then I can separate this for Mr. Chau. And we kept this this Panging's argument. Where are those? I made a note also. Judgments on last occasion. He concluded his argument.
That would be, I think, in his file.
His petition. We will see that. We will see that. I made a note like this, huh? Huh? Judgment भी लगा सकते हैं। File level. Blue file ऐसे जाते हुए रखना होगा। Judgments भी लेके आते हैं ऐसे। ठीक है सर? Written argument starts. Okay, crimes.
Crimes. Just one line, my lord, paragraph 14.
Paragraph 14.
14. There can be other judgments on this point, but I could not locate. So I have decided to rely on this one. Paragraph 14. This is in the context of my power to arrest a person. Here the Honorable Supreme Court has said the above guidelines. What is got my paragraph 14?
With regards to apprehension of juvenile offenders.
Yes.
Huh?
Yes. Paragraph 14, my lord. The above guidelines are merely the incidents of.
No. Paragraph 14. 1/4.
Yes.
It starts with regard to the apprehension of juvenile offenders.
Oh, possibly because I am relying on this Supreme today.
Okay, this is Manu.
Oh, yes.
It starts with
the above guidelines. Guidelines are mentioned, my lord, in paragraph 9, 12 and 13. Third report of National Police.
The above guidelines, paragraph 18.
Yes, I'm sorry, this paragraph is not telling. The above guidelines are merely the incidents of personal liberty guaranteed under the Constitution of India. No arrest can be made because it is lawful for the police officer to do so. Now this is the sentence. My lord. The existence of power to arrest is one thing. The justification for exercise of it is quite another. Well, I'm relying on this line to argue, my lord, that you assuming that you have power.
No, he is in the court to check only, huh? Ask him. Misplaced note yes.
Assuming, my lord, they have power either under section 21 or because oath was not administered to recall that order, then the power can be exercised provided there are situations and the justifications are there. And that is why also Supreme Court said you may have power, but justification for exercise of that power is quite another. You must be able to justify it. You may have power, assuming that you have power. First of all, my submission is you don't have power, except 317. But assuming that they satisfy your lordship and your lordship ultimately holds that yes, they have power because oath was not administered or because of section 21, in spite of my argument on section 21. Then my next submission that power has to be exercised with a justification. You have not been able to justify your exercise of that power. For that, my lord, I'm relying. Next is, my lord, the famous case of Srilaka Vidyarthi, 91 1 SCC, page 212. Possibly a copy I have not given of that, my lord.
Not.
Yes. It to copy to the
This was relied on by my friend Mr. Pani.
Okay.
Srilaka.
Book list to the Asilian.
1991.
Paragraph 30. Well, there are many paragraphs. Paragraph 36, I am relying. This is a case where my law officer
Citation 33 to 39.
Your citation?
1991, volume 1, SCC, page 212, Kumari Srilaka Vidyarthi versus State of AP.
Paragraph?
Paragraph 36 primarily, my lord.
এখানে একটা নোট বানাই থাকা হ্যাঁ this is the judgment last occasion to move down to this.
Paragraph 36. In fact, 33 is also there. 33, 36, and 39. Three paragraphs will be
He relied on 33 to 39.
Yes.
Same judgment.
Yes. So, lordship has seen the judgment, my lord. I don't just repeat. I'm only showing from 36.
I mark it. There is whether there is any discernible principle emerging from the
that is the line. That is the line. Well, that is the line.
Not
and from
satisfied of reasonable.
Absolutely.
That paragraph I have already marked.
And paragraph 13, my lord, the last sentence. If after a
paragraph 30,
39, particularly the last sentence, my lord. If after a prima facie case of arbitrariness is made out, the state is unable to show that the decision is an informed action which is reasonable, the state action must perish as arbitrary. So I need not trouble your lordship with this.
I have already marked it. With pencil. Specifically.
From this next matter is 1974 4 SSC page 3. That is the famous case of EP Royappa matter. Page 38, para 85.
Just give me the citation.
74 4 SCC. Page 3.
Page 3.
EP Royappa versus State of Tamil Nadu.
Paragraph?
Paragraph 85. Only
85.
one paragraph. 85. Well, I will not read the entire paragraph. Somewhat, if you go to paragraph 85, somewhat in the middle, right hand side, Lord, kindly see, from, the word from is there. Equality is there after two lines, right hand side from.
Article 16, though enacted. Though-
Equality is
though
a
enacted-
dynamic
Article
concept.
14, in the words Article 14 is genus, well, Article 16 is species.
Before that, from a positivistic point of view, equality is antithetic to arbitrariness. What is got, my lord? Right hand side, my lord, the word from is there very prominent. Somewhat slightly down the middle.
Slightly down the middle.
Equality is a dynamic concept which may.
Dynamic concept.
Yes.
which may
After
expect
the
a-
next sentence.
From.
From a positivistic point of view, equality is antithetic to arbitrariness. In fact, equality and arbitrariness are sworn enemies. One belongs to the rule of law in a republic, while the other to the whim and caprice of an absolute monarch. Where an act is arbitrary, it is implicit in it that it is unequal both according to political logic and constitutional law. And it is therefore violative of Article 14. And if it affects any matter relating to public employment, it is also violative of Article 16. Articles 14 and 16 strike at arbitrariness in state action and ensure fairness and equality of treatment. They require that state action must be based on valid, relevant principles applicable to alike to all similarly situated, and it must not be guided by any extraneous or irrelevant considerations, because that would be denial of equality. Where the operative reason for state action as distinguished from motive, indistinct from the antechamber of the mind, is not legitimate and relevant, but is extraneous and outside the area of permissible consideration, it would amount to a malified exercise of power, and that is hit by Article 14 and 16. Malified exercise of power and arbitrariness are different lethal radiations emanating from the same vice. In fact, the latter comprehends the former. Both are inhibited by Article 14 and 16. So here is a case, my lord, for employment. You have issued an advertisement. You have undertaken a process, appointed me. And while recalling, you take into consideration certain materials which are absolutely irrelevant and unreasonable to the exercise of power for appointment. Then I'll be relying on that Orissa judgment. Orissa tribunal. This is 2023 SCC online.
Just a minute. 2023 SCC online SC 309.
309. Orissa Administrative Tribunal, I think a copy is there, madam.
A copy is there.
Yes. Paragraph 63 to 66 and 69.
63 to
66 and 69.
That is reply to Mr. Sudhuri.
Yes.
General Project. In apprehension, he is giving reply.
In fact, we argued last time, so both of us know each other's case, man. Mr. Chaudhary is very intelligent. He has written one word somewhere in the affidavit, and he thought that we'll argue. And in fact, in this kind of cases, I should say that it's very good to argue against him. He argues within the limits of argument and doesn't go beyond. That is the beauty, man. So, 63 and 64, like Lord will kindly see for a moment. Just
63.
Yes.
Yes.
We clarify that distinction between quasi-judicial and administrative decisions has been invoked for the purpose of determining whether Section 21 of the General Process Act may be invoked to reverse the decision to establish an SAT. SAT means State Administrative Tribunal. Administrative orders continue to be amenable to judicial review in accordance with law. Section 21 of the General Process Act is otherwise applicable to the Administrative Tribunals Act. Having decided that there is no threshold bar to the applicability of Section 21 of the General Process Act, we now consider whether it applies in the present case. The locus classicus on this subject is State of Bihar versus D.N. Ganguly, where this court held. It is well settled that this section embodies a rule of construction. Section 21 is actually a rule of construction. And the question whether or not it applies to the provisions of a particular statute would depend on the subject matter, context, and the effect of the relevant provisions of the said statute. In other words, it will be necessary to examine carefully the scheme of the Act, its object, and all its relevant and material provisions before deciding whether, by the application of rule of construction enunciated by Section 21, the appellant's contention is justified that the power to cancel the reference made under Section 10(1) can be said to vest in the appropriate government by the necessary implication. If you come to the conclusion that the context and effect of the relevant provisions is repugnant to the application of the said rule of construction, the appellant would not be entitled to invoke the assistance of the said section. We must therefore proceed to examine the relevant provisions of the Act itself. In so, this court held that Section 21 of the General Process Act embodies a rule of construction, and that rule must have reference to the context and subject matter of the particular statute to which it is being applied. Section 21 of the General Process Act can be invoked when its application would not be repugnant to the subject matter, context, and effect of the statute, and when it is in harmony with its scheme and object. The court may refer to the provisions of the statute in so, and this we can avoid, my lord. Then 69, Lordship, may kindly see for the moment. The third sentence starting from the word further.
The problem is that page is not available. We'll get it Xerox 2 copies. Read it.
Yes, I'm just reading. Further, the effect of such an abolition would not be to deprive litigants of a remedy, because the cases before the SAT would stand revived in the forum in which they were pending prior to the establishment of that SAT. This is the important. The subject matter and the context of the Administrative Tribunals Act 2 do not militate against the application of Section 21 of the General Process Act. There is therefore nothing in the Administrative Tribunal Act which is repugnant to the application of Section 21 of the General Process Act. And here the argument was that you have taken a decision to establish the tribunal, now you are withdrawing it. This is contrary to the provisions of Section 21. Therefore, you cannot invoke Section 21 of the General Process Act. The almost Supreme Court has repelled this submission on the ground that the provisions of the Assam, the Central Administrative Tribunal Act 1985 do not militate against Section 21. Here in my case, my lord, I am submitting.
Your case is that there is already a procedure provided.
Yes.
As you have already been appointed,
yes.
Therefore the applicability of Section 20 will not come in a simple language.
Yes, in a simple language. Now, in order to
when would have been a simple thing and there is no procedure laid down for removal, then Section 21 power, because power has been entrusted in a separate manner in the Constitution itself.
Yes. Now,
that is your argument.
That is my argument. And more so when it says it does not militate and it is not repugnant. Here, assuming a case that no, without showing any reason, I recall the order. Now, that will be directly contrary to Section 3, Article 317, because 317 says you have to remove. And in this is the manner. Now, if you say that I have got power under Section 21, my submission will be relying on the judgment that the invocation of Section 21 will militate against the provisions of 317. That is why Section 21 is not available. This is the judgment.
You give that.
I'll judge.
Anything?
Yes, just one judgment. This judgment is final with regard to the oath, my lord. This is 2018, Volume 6, SCC.
Just a minute.
My lord.
Now?
This is 2018, Volume 6, SCC, page 692. Rampal Singh versus State of UP. Paragraph 50, my lord.
50.
This is, my lord, in the context of a right of a member of panchayat to be a signatory of a no confidence motion, because oath was not administered, whether he could do so or not. In that context, my lord, paragraph 450 says, when we read both the observations together, it is obvious that a member who is elected to a house does not cease to be a member only because he had not subscribed to the oath, unless there is a specific provision in this regard. Now, here, in this case, possibly he was not allowed to be a signatory because he had not taken oath. And in that context, it says, but he doesn't cease to be a member, he remains to be a member. Now, once he remains to be, once it is held, my lord, if your lordship holds that he remains to be a member even without oath of office, then possibly, my lord, the argument that oath was not administered, that is why, therefore, we have got power to recall the order, will not hold water, my lord. Para 51, my lord, fourth line of kindly see. He does not cease to be a member, but at the same time, he cannot take part in the business of the house because he has not taken oath. So, in the business of the house, he will not be allowed to take part. But then fact remains that he is a member. Now, if he is held to be, continue to be a member till the oath is administered, then possibly the power to recall cannot be allowed to be there in the authority.
Yes.
Okay, Naiko?
That's all?
That's all.
So we'll take a break for 5 minutes.
Right.
Then we'll come back and conclude by 1.
I should be able to come.
If not, then we'll continue second.
At best, 10 minutes more.
10 minutes we'll continue because no other methods are there. This is separate.
It is there about public interest because they have mentioned in paragraph 8. Just one sentence from one judgment. 99 1 SSC 529. Para 11. 99 1 SSC 529.
99
1 SSC
529. 529.
State of Gujarat versus Suryakant Chunilal Shah. Paragraph 11.
What it says?
What is public interest was explained in the classical decision of this court in Union of India versus Colonel J.N. Sinha. It was pointed out that object of premature retirement of a government servant was to weed out the inefficient, corrupt, dishonest employees from the government service. The public interest in relation to public administration means that only honest and efficient persons are to be retained in service, while the services of the dishonest or the corrupt or who are almost dead wood are to be dispensed with. So here is a case where you are trying to dislodge me against whom there is no allegation of corruption, etc., etc. That's all. Let my plan finish.
Just a minute.
But I think it is not in dispute that the broad parameters in which the challenge has been made is number 1, applicability of Article 370. Number 2, the alternative argument is
not applicable.
assuming it is not applicable. It is an arbitrary exercise of power.
This is the two limb one.
And the third limb that has been added by my learned friend Mr. Mazumdar is Section 21 of General Clauses Act. So I will also confine my argument to these aspects only. So to consider the first limb of the argument, may I take your lordship to the Constitution itself?
Yes.
Article 316. your lordship will find that Article 316 is divided into three sub-articles. Article 316 1 and 316 2 have all along been in existence. 1A was subsequently inserted. Now, each of these have a very distinct purpose. 316(1). The chairman and other members of a public service commission shall be appointed in the case of the union commission or a joint commission by the president, and in the case of a state commission by the governor of the state. We are not really concerned with the proviso. I am not troubling your lordship. Now, for a moment, if we ignore 316 1A and 2 and straight away jump to 317, subject to the provisions of clause 3, the chairman or any other member of a public service commission shall only be removed from his office by order of the president on the ground of misbehavior after the Supreme Court, on reference being made to it by the president, has on inquiry held in accordance with the procedure prescribed in that behalf under Article 145, reported that the chairman or such other member, as the case may be, ought on such ground be removed. It would have been complete. The constitution makers would not have incorporated 316(2) at all. So my purpose of jumping, completely ignoring 1A and 2 and jumping straight to 317 is for the purpose. First purpose is to show that to accept their argument, 316(2) is not at all necessary.
Your case is that
the constitution
entering into office is envisages in the 317(1) itself.
Not 316.
316(2)
envisages the word office is not used in 316(1) at all. The word used is only appointed.
Appointed.
So the constitution makers would have jumped to 317.
So according to you, that this word enters upon his office is having a very relevance in this
and
case.
your cardinal principle of interpretation, when some word or some words figure in a statute or the constitution, due meaning has to be assigned to it.
Your grounds, as I could understand, that first thing is 316(1) is the appointment. Who will appoint? Who will appoint? Governor or president in the case maybe. 316(2) says the term of office.
The manner of entering into office.
Manner of entering into
And
office
it is that.
and continuing his office. And in view of the word used specifically from his office will mean for all meaning, necessary meaning, that it should be after entering into office, he can be removed. This is your argument?
Exactly. The reason is further clear if we come to 1A. Your lordship will kindly come to 1A.
1A.
316(1)(a).
Okay.
This was inserted by the 15th Amendment, 1963. If the office of the chairman of the commission becomes vacant, or if such chairman is by reason of absence, may I pause here for a moment? It envisages that office of chairman of the commission being vacant in two situations. One is vacancy, the other one is by reason of absence, or for any other reason unable to perform the duties of his office. Those duties shall, until some person appointed under clause 1 to the vacant office has entered on the duties thereof, or as the case may be, until the chairman has resumed his duties. So when it is a vacancy, Mere appointment is not enough. He has to enter on his duties. Otherwise, the parliament, we will have to visualize a situation that parliament was merely wasting words while drafting the constitution. It will be rendered, Article 316(2) will be rendered completely meaningless. That is why I started my argument by saying that 316(2) was not at all necessary to accept their argument. It is for a purpose and a reason that the constitution makers expressly inserted, and the word office is not for once referred to in 316(1). The constitution makers in 317 could have very easily said that subject to the provisions of clause 3, I'm sorry. But the constitution makers very easily could have drafted this like this, Madam, 317. Had 316(2) been totally not required, your lordship will read it again, Madam. Subject to the provisions of clause 3, the chairman or any other member of a public service commission shall be terminated or commission's appointment may be terminated. That would have been enough. Why did they consciously use the word remove from his office, and that office is used only in 316(2)? So the language employed in 316(2) has to be assigned a
For
duty.
removal, you will have to enter.
Enter.
According to you, the entering into office means a holding of assuming an office.
Assume.
So assumption is required. As per dictionary meaning and Black's law meaning, that it is entering into office is means and starting of
The logic, as I was giving the example on the last occasion, when an advocate from the bar is elevated or a judicial officer is elevated as an honorable judge of the High Court, the cause list is published the previous day. Oath is taken at 10 o'clock. The name remains ... In the cause list, it is not referred to as Honorable Justice so-and-so. Because till he has taken the oath, he has not become a judge. Or will it not be? Let us test it from another angle. One, Mr. X is elevated from the bar. His name is recommended by the Supreme Court Collegium. Government accepts it. Warrant is issued. But before taking oath, something drastic comes up, emerges, that no, he could not have been appointed. He could not have been recommended, or he could not have been appointed. Will it not be stretching it a little too far to make him go through the entire process of impeachment? And that is exactly, my lord, what I will, one of the judgments, I am in fact grateful to my learned friend Mr. Pangi for placing that Srivastava's judgment, Padma Prasad. That answers this question. I will place the judgment. Some paragraphs have been placed by my learned friend Mr. Pangi. I will place some other paragraphs to show that that is exactly what the Supreme Court did. In case of Srivastava, Supreme Court first stayed the warrant itself. But after having stayed, on the next date when the matter was taken up, it was found that although a stay has been granted, warrant was already issued in the meantime. So what the Supreme Court, I think it was our High Court only. What was done was, since the warrant has been issued, we are staying the oath. Otherwise, had he taken the oath, even Supreme Court could not have interfered. That is the logic. Now, my lord, in the context of these constitutional provisions, your lordship will first come to the order of appointment, which your lordship, I am entirely going on Mr. Panging's,
Okay,
because that has all the facts.
okay.
Just for the purpose of one document, I'll come to the other case. my lord.
Hmm.
First, your lordship will kindly come to page 82.
Page
82. That is the order of appointment.
818.
82.
82.
82.
Hmm.
One of the first things that your lordship will note in this order, in exercise of powers conferred under clause 1 of article 316 of the constitution, read with clause 4 of Arunachal Pradesh Public Service Commission Regulation 1988, the governor of Arunachal Pradesh is pleased to appoint Ms. Rosie Taba as member, Arunachal Pradesh Public Service Commission. The pay and allowances of the post shall be governed by clause 6 of the Arunachal Pradesh Public Service Commission Regulation as amended from time to time, with effect from the date she assumes the charge of the office. Now, next paragraph is important. She shall hold office for a term of 6 years from the date on which she enters upon the office, or till she attains the age of 62 years, whichever is earlier, in terms of provisions of clause 2 of Article 316 of the Constitution of India. So, this order itself makes it conditional that the clock will start ticking. The tenure will start once there is a compliance of 316(2). First paragraph under clause 1 of 316, appointment is made. Second paragraph, the clock will start ticking the day you enter upon the office in terms of 316(2). Now, your lordship will find at page 46 of this writ petition, the regulations. In my friend Mr. Panging's case, this regulation has been annexed. And your lordship, my learned friend had already placed regulation 4. Now, in this case, in this writ petition, your lordship will find at page 60, one of the amendments. 60. In the other writ petition, these documents are not even annexed. At page 60, your lordship finds one of the amendments. But interestingly, this is the second amendment to the regulations. In exercise of the powers conferred by the proviso to Article 318 of the Constitution of India, Governor of Arunachal Pradesh is hereby pleased to make the following rules further to amend the so-and-so regulations 88. Short title, etc., etc. Insertion of clause 4B. Your lordship will kindly note this one. So, prior to this amendment, 4A has already been inserted. But that 4A amendment is not annexed to this writ petition.
What was the 4A?
I will take your lordship to that. In the Arunachal Pradesh Public Service Commission Regulation 1988, after 4A, the following shall be inserted. 4B. The governor of Arunachal Pradesh or his nominee shall administer oath of secrecy. Your lordship will kindly mark this one. Oath of secrecy to the chairman and the members before entering upon the office on the following terms. And your lordship will also kindly mark the word before. So, when the writ petition was filed by Colonel Kostari, that is being represented by my learned friend Mr. Mazumdar, and this writ petition, Rosie Taba, by my friend Mr. Panging, when they urged non-applicability of Article 317, there was perhaps an impression that there is no mandate of taking an oath for entering upon the office. Because none of these, in the other writ petition, even the regulation itself, original regulation itself is not annexed. Here, what is annexed is the original regulation and the second amendment, 4B amendment. Now, what is 4A? your lordship will kindly take our affidavit.
In this case,
This case itself.
page,
Page 17 of our affidavit.
page,
17, 17. This is an affidavit.
I've got it.
Mark,
Just a minute. Page
17, 17.
17.
17. In exercise of powers conferred by the proviso to Article 318 of the Constitution of India, the Governor of Arunachal Pradesh is hereby pleased to further amend the Arunachal Pradesh Public Service Commission Regulation 1988, namely, the short title, etc., may be skipped. Insertion of 4A. In the Arunachal Pradesh Public Service Commission Regulation 1988, after clause 4, the following shall be inserted. 4A. The governor of Arunachal Pradesh or his nominee shall administer the oath of office to the chairman and the members before entering upon their office on the following form, namely. So, oath of office, and it has to be done before entering upon the office. And this is a regulation framed under Article 318 of the Constitution. So this has the backing of the Constitution itself. Now, I will address that aspect also. An argument in the context of Section 21 has been made that if it runs contradictory to the existing scheme, constitutional scheme, then Section 21 will not apply. Where is the contradiction? Constitution speaks about entering upon the office. How you will enter into the office is laid down by the regulation. Where is the contradiction? Constitution says that you will enter. How is absent? So that
how has been delegated by the Constitution according to you, and that under 318, and they have exercised their power under 318.
And your lordship will kindly note the argument that has been advanced virtually throws a challenge to the amendments 4A and 4B, and 4 and 4B are not under challenge. 4A and 4B have been, after we placed it on record, they could have very well challenged it to even maintain this argument that this runs counter to the constitutional scheme. It has to be first struck down by your lordship. Otherwise, if it continues to exist, it cannot be ignored. So, therefore, my lord, the mandate of 316 is that you have to enter into the office. And if you enter into the office, you cannot be removed without following the procedure in 370. So that entering into the office had not happened in the instant case. Now, my lord, only one judgment with regard to the oath has been placed, that is 2018. Your lordship will find that pertains to a member of Legislative Assembly. The answer to that lies in Article 193.
193.
Your lordship will find very interesting in respect of all other positions, except for MLAs and MPs. In respect of MLAs, the Constitution itself says that even without taking oath, you can do certain things as an MLA. Has my lord got it? 193.
Yes.
The heading reads like, I'm sorry.
Yes.
Heading reads like this one. Penalty for sitting and voting before making oath or affirmation under Article 188 or when not qualified or when disqualified. So if your lordship comes back to Article 188, it is oath of affirmation by members. Now, if a person sits or votes as a member of the Legislative Assembly or the Legislative Council of a state before he has complied with the requirements of Article 188, or when he knows that he is not qualified or that he is disqualified from membership thereof, or that he is prohibited from so doing by the provisions of any law made by Parliament or the legislature of the state, he shall be liable in respect of each day on which he so sits or votes to a penalty of 500 rupees to be recovered as a debt due to the state. So, the Constitution itself has made a provision. So, therefore, the judgment in 2018. Otherwise, what is the importance of an oath? I have looked through, my lord. There are no Supreme Court judgments, but there are some High Court judgments, which I'll place reliance on. But before that, my lord, one of my first submissions on 316 and 317 is that this requirement of these words enters upon office, then the word appointed, to accept the arguments that have been advanced. Some words will have to be replaced, some words will have to be substituted, some words will have to be completely excluded to accept their contentions, which is not permissible in terms of the settled propositions of interpretation. On that, my lord, I will place the judgment of Grasim Industries. That is 2002.
Just a minute.
4 SCC 297.
Let me see whether already copy is here. 2002.
4 SCC 297.
Not here.
That perhaps the SCC judgments perhaps I had not given last time.
Okay.
It is only the judgments which are not readily available, those copies I have given.
Okay. Paragraph?
Paragraph 10. No words or expressions used in any statute can be said to be
Just a minute. Paragraph
10.
This is 2002 4 SCC 297.
297. Grasim Industries.
Grasim Industries. Just a minute. Yes, no words.
No words or expressions used in any statute can be said to be redundant or superfluous. In matters of interpretation, one should not concentrate too much on one word and pay too little attention to other words. No provision in the statute and no word in any section can be construed in isolation. Every provision and every word must be looked at generally and in the context in which it is used. It is said that every statute is an edict of the legislature. The elementary principle of interpreting any word while considering a statute is to gather the mens or sentential edges of the legislature, where the words are clear and there is no obscurity and there is no ambiguity, and the intention of the legislature is clearly conveyed. There is no scope for the court to take upon itself the task of amending or altering the statutory provisions. Wherever the language is clear, the intention of the legislature is to be gathered from the language used. While doing so, what has been said in the statute as also what has not been said has to be noted. The construction which requires for its support addition or substitution of words or which results in rejection of words has to be avoided. I am heavily relying on this sentence. As stated by the Privy Council in Crawford versus Pune, we cannot aid the construction legislature's defective phrasing of an act. We cannot add or mend and by construction make up deficiencies which are left there. In case of an ordinary word, there should be no attempt to substitute or paraphrase of general application. Attention should be confined to what is necessary for deciding the particular case. This principle is too well settled and reference to a few decisions of this court would suffice. But what I'm trying to say, by relying on this judgment is virtually 316(2) will in entirety will have to be ignored to accept their contention. If not in entirety, at least that requirement of entering into office and the word office as used in 317 will have to be virtually treated to be terminated. Because an appointment, the constitution makers would have very easily stuck to 316(1) and said that such appointment can be terminated by following the procedure laid down in such. The constitution makers would not have used a battery of words in the form of 316(2) and thereafter use the same word office as it finds place in 316(2) in 317. So my first limb argument is that this will require, to accept the interpretation put forward, this will require addition and deletion, which your lordship will not do. Now, my lord, this is a very interesting case. With regard to oath and the significance thereof, there are three judgments: Allahabad, Patna, and Calcutta. Now, in Allahabad, what had happened was, Allahabad too. In Allahabad High Court, 3 honorable judges were appointed. Well, this is
2000.
This is 1964.
63.
63 SCC online.
Yes.
To understand the facts, your lordship will come to the first paragraph itself. Has my lord got it? The criminal division was listed for hearing before Satish Chandra J, who along with Kapoor and Tripathi JJ was appointed to be an additional judge of this court in the beginning of October 1963. All of the 3 made and subscribed to the following oaths in the presence of the Chief Justice of the court on 7/10/1963. I am skipping the form, madam. The Chief Justice purported to act under a letter of authority dated August 25, 1963, addressed to him by the governor of Uttar Pradesh. The letter reads, we may skip this one. Now, paragraph 3. So the oath was administered on 7th of October. And on 18th, this happened, para 3. On 18th October 1963, it was discovered that the Constitution 16th Amendment Act 1963 had received the assent of the President on 5th October 1963. And by means of Section 5 of that Act, the form of the oath required to be made by a person appointed to be a judge of a high court had been slightly amended. Consequently, the same day, in the afternoon, the 3 judges mentioned above made and subscribed oaths in the presence of the Chief Justice in the following amended form. In the amended form, the oath was administered. Next, para 4. The revision application came up for hearing before Satish Chandra J on 23rd October 1963, when a preliminary objection was taken that not having taken the oath in the correct form, he could not act as a judge. And the oath that he made and subscribed on 18th October was bad, as the Chief Justice could not have acted for the governor without there being a fresh and specific appointment of the Chief Justice by the governor to be present and witness the oath being made and subscribed by Satish Chandra J. Satish Chandra J then made a reference saying, I refer these questions to a larger bench for decision without framing the questions. The matter has now been placed before us. The oaths that the learned judges mentioned above made on 7th October 1963 would have been correct if the amending act had not been passed or had not received the assent of the President before 7th October 1963. These submissions have been made before us by Sri So-and-so. That the amending act having received the assent of the President on 5th October 1963, all persons who took oaths of office on that date or on subsequent dates could only do so in the amended form, and that inasmuch as Satish Chandra J did it in the original form, he had not made and subscribed a proper, your lordship will kindly note this word, proper oath, and consequently had not entered upon his office. Now, these questions have been answered. Your lordship will first come to para 7. the requirement of making and subscribing oaths by a person appointed to be a High Court judge has existed throughout. It admits of no argument that a person appointed to be a judge of a High Court can only enter upon his office after making and subscribing the oaths required by the law. It is the performance of the oaths that marks the induction into office. Your Lordship will kindly note this. It would be noticed that Article 219 of the Constitution uses the words every person appointed to be a judge of a High Court and not every person appointed a judge of the High Court, which would indicate that a person appointed to be a judge becomes one only after oath has been made and subscribed by him. Before that, he is what may be called a judge designate. That article also provides that the oath should be according to the form set out for that purpose in the third schedule. Now, this portion is very, very important. The expression shall, before he enters upon his office, make and subscribe clearly shows that making and subscribing of oath is a condition precedent to the assumption of office. It is tried that the non-performance of a condition precedent cannot be treated to be a mere irregularity. Your Lordship will kindly note this because this is one of the arguments, that it is a mere formality. In our judgment, therefore, the provisions of Article 219 of the Constitution are mandatory at any rate, so far as making and subscribing of oaths is concerned. We find support for our view from Sunil Kumar, this is the Calcutta High Court judgment, and Brahmeswar Prasad, this is the Patna High Court judgment. And in one of the cases, the president had taken oath after independence at 10:50. And even in case of the president, it was held that he had not entered into the office. Now, Your Lordship will kindly come to para 36 of the same judgment. It is contended that the passage reproduced above is an authority for the proposition that the taking of an oath is not of the essence. We are unable to agree with this submission and have no doubt that the effect of the passage is in the reverse. It clearly mentions that the making of the oath marks the induction into office. We have ourselves said earlier that the oath confers no new obligations. The obligations to discharge the functions of the office diligently, consciously, and are not dependent upon the taking or non-taking of the oath. They are inherent in the acceptance of the office. But merely because the taking of the oath casts no new obligations would not justify the inference that the oath or its form is dispensable. Now, there's a passage from Halsbury that has been extracted. I'm skipping that, my lord. Your Lordship will kindly come to para 38. This passage, in our opinion, wholly militates against what the learned Advocate General has contended and supports our view that making and subscribing of oaths according to the prescribed form is a condition precedent to entry upon office, and failure to perform the same results in vacation of the office if assumed for reasons mentioned above. That the provisions of 219 of the Constitution, even in respect of the oaths being taken according to the form prescribed, are mandatory and not merely directed. Now, my lord, I am not troubling your lordship with the Patna and the Calcutta, but there is a Kerala High Court judgment that also your lordship will find in that bunch of. I will just. Here, this is a full bench of Kerala High Court. It was, I am not troubling your lordships with the rest. Here, the Kerala High Court has taken it a step further. Paragraph 8, just one sentence I will rely on. Here, the allegation was that a member of parliament had breached the oath, and there was a challenge on that count. So, in this context, the full bench of the Kerala High Court had the occasion to deal with the situation of breach of oath and absence of oath. And this is what the Kerala High Court said. Para 8. breach of oath is different from absence of oath. Absence of oath prevents entry into office, while breach affects the continuance after valid entry. So, if there is no oath, it prevents entry into the office. So, the other judgment says induction into office, and this says that if there is no oath, it prevents entry into the office. The clock will not start ticking. So, therefore, my lord, in my respectful submission, since the oath was not administered, for whatever reasons, the reasons will come at the second limb of the argument. Whatever be the reasons, it is an admitted fact that the oath was not administered. So the oath not having been administered, the rigors of 317 will not come into play in any.
According to you, oath not having been not administered, there is no entry into the office. There is no not being any entry. There is no question of
Removal from
the office. This is your argument.
Exactly. Now, my lord, coming to the second limb of the challenge. The second limb of the challenge is that there was a public demand. In fact, my friend Mr. Mazumdar was very candid in his submission when he said that it is not public interest, but it is public demand. So, to the extent of the public demand, he is admitting. Now, let us test. And in fact, this is a pleaded case in Mr. Panging's case that I will show from the pleadings. But first, let me place some facts, sequence of events.
Just give me a minute. I'll just mark your this in judgments. Yes.
Just a few dates, madam. The date of appointment is 7/2/23.
7/2/2023.
Thereafter, the petitioners were intimated about the oath on 15/2/23, and the oath was to be administered on 17/2/23. They were intimated about it on 15/2. And the date was fixed for administration of the oath on 17/2/23. Now let us understand what happened. Your Lordship I am taking it first, taking it their own pleaded case, and then I'll take your Lordship to our pleaded case. Their pleaded case, your Lordship will find that paragraph 21. In Rositaba case, that is WPC 213, the petitioner herself narrates the sequence of events. Para 21. If your Lordship, I'll read it very slowly. Or your Lordship, if your Lordship wants to mark it.
Page?
Para 21 and page 22. That the petitioner begs to state that the aforementioned communication dated 15/2/23 also went viral on various social media platforms, and netizens started making all sorts of assumptions and comments, and huge mass hysteria was created to stop the oath-taking ceremony of the chairman and the newly appointed members of the APPS. Accordingly, consequent to the mass hysteria created on social media, without there being any actual reason as to why the appointments of the chairman and members of the APPS were to be stopped, thousands started converging at the tennis ground, Itanagar, on the night of 16/2/23. The mass hysteria became all the more prominent consequent to appeals being made on social media by self-styled activists. That next parameter, that on the morning of 17/2/23, the law and order situation in the whole of Capital Complex erupted with thousands blocking the road leading to Raj Bhavan and fighting pitched battle with the security forces and large-scale destruction of public properties by the agitators. So it is their own pleaded case that there was a mass movement that happened on 16th and 17th. Now, we also say that yes, at this stage, your lordship will kindly make a note of one thing. An impression is sought to be done that some handful of people raised a chaotic situation. Because of that, the government succumbed to pressure. That is the sort of impression that is sought to be given. Now, it is their own pleaded case at paragraphs 21 and 22 that it was a large-scale agitation that started. What did we do? We are an elected government. We have to go by the wish of the general public, the people of the state. We are not running a monarchy. It was there is not a Your lordship will kindly make a note of one interesting fact. There is not a single material placed on record by them to show even one person or one organization who opposed this movement. So therefore, it is only reasonable to presume that as they plead in paragraphs 21 and 22, it was an unprecedented public demand, overwhelming public demand, and that public demand was not opposed by any other member of the public. So that is an indication of the unanimous desire of the public. What we do is at page 89 of this has a relevance. When this large-scale public movement started, your lordship will kindly make a note of the date, page 89. An emergency cabinet meeting was called. 17th of February.
They stated also. They pleaded it.
Yes, it is from their pleadings I am pleasing.
When meeting went on for around 8 hours in the government in order to assess the situation considering the visit of French. Anyway, answer.
I'm not going by their pleadings, I'm going by the documents themselves. Page 89. An emergency cabinet meeting was called on 17th of February. In view of the request placed by the so-and-so, the cabinet has decided to call off the swearing-in ceremony of the chairman and members of the Arunachal Pradesh Public Service Commission. It was further decided that this matter will be discussed with all community-based organizations and stakeholders of Arunachal Pradesh. Two decisions are taken. Number one is we are calling off the swearing-in ceremony. The reason I am showing your lordship this is exactly what was done by our High Court in Padma Prasad's case. First, because what does your lordship do when a requisition is moved? This matter requires further examination. In the meantime, stay. That is what the government did. We said, well, we are calling off the swearing-in ceremony. We'll examine now. Thereafter, on 18th, these documents were placed, but the dates are relevant. On 17th, emergency cabinet meeting, and your lordship will kindly note the date. Next page, page 90. On the very next day, these stakeholders were allowed to place their grievance. And that is a decision taken by the cabinet that we will interact with the stakeholders. And accordingly, that interaction with the stakeholders is done in none less than the Chief Minister's conference hall. Various high officials were present. Now, what is decided? This was placed, page 93. This was placed by my learned friend, Mr. Pangi. The demand for cancellation of order, the present chairman and members of the PSC was agreed. The same will be taken to the cabinet for approval. A fresh search committee will be constituted. A column for declaration of properties of all the applicants will be added in the application form. Now, it is not as if we could have taken an equally hasty decision on the very next day. We did not. And ultimately, the cabinet decision is at page 101. And your lordship will kindly make a note of the date. From 18th of February till 29th of March.
Page 102.
101.
101.
After more than a month, everything is not, all things may not be reflected in the records. The timeline shows. We could have simply, very next day, we could have, if it was such a perfunctory exercise, we could have done it next day. Or as they say, the president was supposed to visit on 20th. So after the 20th, on 21st, we could have done it. Why did we take the time? The timeline itself speaks volumes about the decision-making process. It is not that one or two persons come and pressurize us and we succumb to them. It is not that. The overwhelming nature of the demand, unopposed demand. And what are we? We are an elected government, representatives of the people. So in the cabinet decision also, in the earlier cabinet decision, if your lordship comes back to page 98 and compares, your lordship will find one very interesting, I'm sorry, Malan, this was at page 89. Your lordship will now compare page 89 with page 101.
That's fine.
The reason I'm showing the difference is very interesting. Your lordship will find at page 89, the reason recorded is, in view of the request placed by Arunachal so-and-so forum and Pan Arunachal so-and-so, the cabinet has decided to call off the swearing-in ceremony. And at page 101, there is not even a passing reference to all these. All it says is after detailed deliberations. So, when we found that there is an overwhelming public demand, unopposed public demand, a detailed deliberation took place by the cabinet, and ultimately in public interest, it was decided to recall, and the recall order again is at page 102, which has been placed. And this says that it has been done in public interest. Now, the relevant paragraph has been placed by my learned friend, paragraph 8 of the other affidavit. Similar is the position, my lord, paragraph 16 of the affidavit file here. In WPC number 213 AP 223. Page 9, my lord, of the affidavit in opposition. It's paragraph 16.
Page 16. Page 6.
No,
You want to say?
this is affidavit in opposition by the respondents 1, 2, 3, and 4.
Oh, 1, 2, 3, and 4.
Then para 16 at page 9.
Para 16 at page 9. Yes. Yes.
That the statements made in paragraphs 26 and 27 of the petition are incorrect, etc. Hence, the same are categorically denied. It is categorically denied that the appointments of the so and so were recalled due to popular demand. The answering respondents humbly beg to state that owing to unprecedented public demand, the Honorable Chief Minister invited all the stakeholders, including so and so, on 18 to 23 to discuss the issues raised by the public. In the said meeting, 13 demands raised by the ANSU were discussed and the stakeholders were updated with regard to the steps taken by the government thereon, etc. It was further decided to constitute a fresh search committee. It was further decided that in terms of the suggestion given by the public, a column for declaration of the properties of the applicants would be added in the application form. Pursuant thereto, the matter was considered by the cabinet in its meeting held on so and so, and it was recommended to recall the appointment orders in public interest. Thereafter, the governor was so and so. And para 8 of the other affidavit, almost similar.
Same. Almost same. That we have already noted.
There are basically, I was trying to lay emphasis on two things in para 8 of that. Your lordship may just make a note. Well, in para 8, we have said there was an unprecedented public demand. And the second thing that has been said is invited all the stakeholders, interested people, whoever wanted to. We called them, we heard their grievance, and thereafter proceeded, deliberated upon the issue, and the final decision was taken by the cabinet. Now, my lord, the entire argument is that an agitation is made, agitation is resorted to, and you, based on that demand, public demand, you agree to it. Where is it wrong? That is why I had placed, just to show what is the purpose with which our constitution was framed. Your lordship will kindly have the Constituent Assembly debates. Unfortunately, today my
Yes.
Constituent Assembly debates. I just wanted to indicate what is the foundation on which our constitution was framed. If your lordship comes to the third page thereof, I just will read out 2 sentences. Third page of that compilation of Constituent Assembly debates, volume 11. Third page, in the very first paragraph, third line from top, there is a sentence starting this constitution.
First paragraph?
Yes.
Is
third page of that.
1, 2, 3. It starts with sacrificed their life.
Yes. Third line, there is a sentence starting
this constitution.
This constitution which we are going to present to ourselves is based on democracy. The world is after democracy, and we are also following the same path. According to Abraham Lincoln, democracy means the government of the people, by the people, for the people. We have framed our constitution according to that principle. So, merely to say that we have accepted the public demand by itself has no relevance whatsoever. We are bound by the wish of the people. We are bound by the desire of the people. It is rather all the time we are debating in our drawing rooms that the government does not listen to the people nowadays. That is the debate, because that will violate the principles of democracy. That will amount to anarchy. That will amount to a monarchical approach of governance. A government is required to listen to the people. And in that context, my lord, I had placed. That is why the other day I had said, my lord, had all consequences of agitation been bad, our independence would have been struck down by the British courts in 1947 itself.
Now,
your lordship will kindly have the first, my lord, just to indicate what was done in that Padma Prasad case. I'll first place that is the reason I had placed the cabinet decision of calling off, staying the oath-taking ceremony. And this is exactly what was done in Padma Prasad's case. It is 1992, volume 2, SCC 428. My learned friend, Mr. Pani, had placed it. He had placed paragraphs 27 and 28. I would just like to show the approach adopted by the highest courts of our land. Just a second. Your lordship will kindly come to paragraph 7. 1992. 1992 2 SCC 428.
Just really slow.
It was placed by my friend.
It was placed on last occasion.
It was placed on
Paragraph?
Paragraph 7. This I wanted to show that exactly what was done by our cabinet. First state and then examine. This is exactly what was the approach of the courts. I'll just read very slowly. Kumar Padma Prasad, a practicing advocate, filed a writ petition under Article 226 of the Constitution of India before Guwahati High Court on October 23, 1991, challenging the selection of Srivastava for appointment as a judge of the Guwahati High Court on the ground that he was not qualified for such an appointment. He prayed for issuance of a mandamus directing the Union of India and other respondents to recall, rescind, etc. That we are not concerned with. I am concerned with the order passed by the stay matter shall be heard. This was the first order passed in our High Court. The stay matter shall be heard on October 28, 1991. Meanwhile, the respondent number 1, Union of India, is restrained from issuing warrant appointing the respondent number 9 as judge of the Guwahati High Court till October 28, 1991. On October 28, 1991, High Court noticed the fact that the warrant of appointment of the Srivastava has already been received at Guwahati. The petitioner was permitted to amend the writ petition and the hearing on the interim relief was adjourned to November 6, 1991. A division bench of the High Court heard the stay matter on November 6, 1991. After noticing the points raised by the petitioner, the High Court observed as under. In view of the above discussion, it is doubtful if the respondent number 9, Srivastava, possesses qualifications as provided under so-and-so. Therefore, a bona fide dispute has been raised thereby showing a prima facie case. The High Court granted the interim stay in the following words. In the result, it is ordered and directed that the warrant of appointment of respondent number 9, Sri so-and-so, issued by the President of India shall not be given effect to by the concerned respondents until further orders. This portion. It is further ordered and directed the respondent number 9, so-and-so, is restrained from making and subscribing his oath or affirmation in terms of Article 219 of the Constitution until further. Because the Supreme Court realized that whether qualified or not, Had he been administered the oath, the only way to remove him is impeachment. Even the hands of the courts will be tied. So that is exactly what we did. Here, an argument in reply might come that here the eligibility itself was in question. I am not on that. I am on the procedure adopted by the cabinet. Now, my lord, if your lordship will kindly come to the Citizenship Act. I had given a copy, my lord. Citizenship
I am
Act
having it.
Amendment Bill 1985. And
Purpose of giving effect to certain provisions of memorandum of understanding relating to settlement of foreigners issue in Assam Accord.
Well, I am not on that, my lord. I am on the statement of objection reasons. It is in the penultimate page of that bunch. I think it will be the 4th page of that bunch. Statement of objection reasons. The core of the memorandum of settlement, Assam Accord, relates to the foreigners issue. Since the agitation, your lordship will kindly mark this word. Their whole case is that agitation was resorted to and the government succumbed. Agitation launched by ASU. Who is ASU? A students' union. Arose out of their apprehensions regarding the continuing influx of foreign nationals into Assam and the fear about adverse effects upon the political, social, cultural, and economic life of the state. Assam Accord being a political settlement. Legislation is required to give effect to the relevant clauses of the Assam Accord relating to the foreigners issue. So, based on a political settlement, on account of an agitation resorted by a students' organization, the Parliament amended the Act and inserted Section 6A. Another example is, my lord, the Borough 6th Schedule Amendment. And the statement of objection reasons is again in the 4th page. Your lordship will come to the 2nd paragraph. The Borough Accord was signed on February 20, 1993 with All Borough Students' Union and Borough People's Action Committee with the objective to provide maximum autonomy to the boroughs within the framework of the Constitution for their social, economic, educational, and cultural advancement. In pursuance to the Borough Accord, an interim Boroughland Autonomous Council was constituted by the government by enacting legislation. Borough groups were of the view that Borough Accord had become unworkable due to non-implementation of the accord in letter and spirit. Based on the tripartite talks, a memorandum of settlement has been signed between central government, the government of Assam, and your lordship will kindly note the next organization. Borough Liberation Tigers, which was a designated terrorist organization. And the constitution here was amended. If you have to represent the people, you have to go by the will of the people, the desire of the people. That is the mandate of our constitution. And that is what we have done. Now, my lord, there is a very interesting judgment. This is in, the context is slightly different. In the state of Punjab, an issue had arisen whether some parameters are required to be laid down for appointment of Public Service Commission members and chairman, etc. There is a very interesting passage. This is the citation is 2013. 2013, volume 5 SCC, page 1. We are not really bothered about what was done in this case, but I just want to point out one of the things that was noticed by the Supreme Court, which is a
Paragraph, citation,
Citation is 2013 volume 5 SCC,
5 SCC,
page 1.
one paragraph,
I am relying on paragraph 94
90.
because this paragraph, amongst various other things that are required for a chairman and a member, one of the things that the Honorable Supreme Court recognized was the person who is going to be appointed as a member or a chairman is required to command the confidence of the people. Here, paragraph 94,
Just a minute.
it relies on Ashok Kumar Yadav.
Paragraph 69, State of Punjab.
State of Punjab versus Salil Sablok.
48,
It is at page 51.
50.
50.
Yes.
Paragraph 94 quotes Ashok Kumar Yadav versus State of Haryana, that famous case, or rather the infamous case. Then paragraph 30 in the second portion, in regard to the second requirement, it was said, as my lord got it. Paragraph 32 portions are quoted. In regard to the second requirement, it was said, we would therefore like to strongly impress upon every state government to take care to see that its public service commission is manned by competent, honest and independent persons of outstanding ability and high reputation who command the confidence of the people. Your lordship will kindly note this. And who would not allow themselves to be deflected by any extraneous considerations from discharging their duty or making selections strictly on merit. So one of the requirements that was noticed by the Supreme Court as far back as in Ashok Kumar Yadav, which is 1985, and reiterated in 2013 by the Supreme Court in the Punjab Public Service Commission case, is they have to command the confidence of the people. Here they did not command the confidence of the people. Since they did not command the confidence of the people, now this is so far as this
second limb of our
second claim. Now just to rebut what they have said. Article 317, I have addressed your lordship at length. I won't unnecessarily trouble you about it. 2018 6 SCC was placed by both my friends. The answer, as I pointed out, is Article 193. So that principle will not have any application here. Padma Prasad case was placed paragraphs 27 and 28. Here, this I have again placed to show that oath itself was stayed because the courts were conscious. Otherwise, it has to go for impeachment. And that is exactly what we have done. Now, my learned friend Mr. Mozumdar started his submissions by showing the background of the petitioner. We are not disputing. We are not disputing that he is a highly qualified. He might be. There are so many highly qualified persons. But that is that would have no relevance whatsoever. Now, one of the submissions that was made was that in view of the language employed in 316(1), the appointment in itself is complete. And the oath is a mere formality, which again, I have placed the judgment. Allahabad High Court judgment very clearly says that it is not a mere formality. It means induction into office. And the other one says that it will be prevented from entering the office. That Kerala. Now, coming to this submission regarding Section 21 of General Clauses Act. This entire argument on Section 21 of General Clauses Act and the judgments that have been placed presupposes that 317 is applicable. There is no.
He has argued that in apprehension that you will argue Article 20. You have not argued, so we will give it up. You will give that up. And there is no question of Article 20. That was in apprehension Article 21. That
Section
he
20.
thought that he will concede that 317, even if then also 21 will save your action.
That is automatic. Because 317 is not applicable. The power to appoint includes power to recall the appointment. Now, first, to accept the contention on 317.
No, that application, your history the moment you argue that it's co-related, 316 and 317, and starting the office, entering into office is important. If that argument is allowed by this court, then question of 21 will not come.
Will not even.
Will not come.
That is my answer. Now,
And if we hold, then only your argument will come.
Now, my lord, some judgments were shown on arbitrariness, etc., etc. To buttress that, I have shown that yes,
You have the
justification. There is an overwhelming public demand, unopposed,
and immediate.
and they are not even after so much of opportunity, so much of time has flown. They have not been able to place one single document to show that that public demand was ever opposed, saying that Rosie Daba and Colonel Kostari should be allowed to continue. Not a single document on record. So therefore, my lord, all those, and we are saying that we are a government of the people, by the people, for the people. There was an unprecedented, overwhelming demand. The people did not have these people did not have the confidence of the public at large. That is, and that has been accepted to be a valid ground by the Supreme Court in Ashok Kumar Yadav, followed by Salil Thakur. So therefore, my lord, looked at from any angle, these writ petitions deserve to be dismissed, and we may be allowed. We are going without a public service commission for several months. So, my lord, finally, hopefully, we will be able to have the office functional. Your lordship is aware, my lord, how difficult it is. Public service commission, so many functions are involved. Right from promotions, selections, then on occasions, my lord, approval of the rules, draft rules, etc., etc. So many things. So therefore, my lord, my respectful submission, my lord, these writ petitions deserve to be dismissed at the earliest, so that we can resume our function.
That's all.
5 minutes.
Also to reply, because on the factual part, these are not pleaded cases.
Factually, I have not brought any new facts.
All the submissions.
No, will you hear it? Don't worry about it. We'll conclude today itself.
I'll take only 5 minutes. My lord, so far as the some facts relating to the decision taken that.
Just a minute. Just a minute.
Your lordship will excuse me for just 2 minutes.
You are excused.
I'll come back.
Totally.
You may not reach back even.
Yes. I'll be very brief.
Yes, please.
My lord, initially when my learned friend Mr. Chaudhary was showing that they have undertaken a exercise where immediately they have not taken any decision so as to say that the decision is not perfunctory. My lord, their affidavit, paragraph 88, which I have read, says that this demand, public demand, which they have for the first time considered and taken into consideration on 18th of February, and on that day itself, they have mutated to recall. It is another thing that subsequently on 29th of March, it was recommended to recall, and an actual recall took place on 18th of April. But then decision to recall was taken on the very first day, that is on 18th of February 2023, when they held the first meeting to consider the representation. So it was actually perfunctory if I go by my number one. Lordship will find in paragraph 87, they have admitted that on the very first day they have it was inter alia minuted to recall the appointment. So that is clear that on the very first day they have taken decision. It is another thing that they have deferred the decision, recommendation, then final order, but then decision to recall the appointment was on the very first day, and it was completely under the pressure of the public demand. Statewide agitation was there. Possibly there was a fear of the government falling. So all those things are irrelevant to the question as to whether an appointment made in the Public Service Commission should be recalled or not. Secondly, my lord, the public demand My learned friend is repeatedly saying that there was a public demand. In a democracy, we have to hear the public. Very good. But what is the demand? If we go by the specific, fortunately, we have the demand in writing and we have the specific points of demand. None of the demand says that our appointment should be recalled. So what are you considering? You are considering the pressure from the public and then you are taking a decision. In between, you have to justify the order. The Supreme Court in minority, if the Royapa just read one line once again, says that you have to justify. Public demand is what? Public demand not for recalling of this appointment. Public demand to take action against the erring officials in the 2014 and 17 selections. Public demand was never for recalling or cancelling the appointment made now. Public demand was to take action. I will not read the public demand. It is very specific. 1, 2, 3, 4, 5, 6, 7. None of the demand says that our appointment should be cancelled. It only says that please take action against the erring officials who were involved in the scam of 2014 and 17. You are succumbing to the pressure of the public demand. It's all right. In a democracy, as per Abraham Lincoln, it is for the people, of the people, by the people. But what is the demand? That you are not arguing. Government is not saying that the public demand is to recall this appointment. They are saying there is a public demand, we have taken the action. What action? If the public demand is to do something and you do something else, can you justify on the basis of public demand? You cannot. You have to justify your action. Action you are taking. Public demand is there. You have to listen to the public. That is also there. But public says, listen to me. For singing a song, you say, no, I'll eat rice. That cannot be justified. Your action and the public demand must be related to each other. There is no relation. Public demand is to take action against 2014 and 17 erring officials. Action is not against them. Action is against the subsequent appointees. So there is no link. Public demand and the action, there is no link, my lord, we can consider that. So that shows that the decision is arbitrary because there is no justification for the decision you have taken. Public demand was something, decision is something else. And my lord, that is with regard to the public demand. And the ASUS and Bodo organization has been cited to show that, see, because of the public demand, the Citizenship Act was amended, Section 60 was inserted, and thereafter 71, 66, all this came. My lord, you can see, these amendments came because of the judgment passed in Sarbananda Sonowal's case. Sarbananda Sonowal, I will not refer it so, my lord, hackneyed by now, that it is absolutely clear that because of the immigration in Assam, the Supreme Court has clearly and in unambiguous terms mentioned that there was internal security and there was external aggression. And it is because of this that the Citizenship Act was amended, not because of the mere demand and broadness of the demand and my lord, the intensity of the demand. It is because the Supreme Court clearly realized, and my lord, in that case, I read in connection with all these foreigners matters I am appearing for the government. I have read it again. Sinha's report clearly says how much people, when, how they came, and what is their intention. Everything is there in the report of Sinha. Everything is there, and Supreme Court has taken note of that and then observed that there is a clear internal threat to the internal security and external aggression, unless you immediately amend the Citizenship Act. And it is not because of the public demand by ASU and Bodo organization. It is because there is a threat to the security of the country. And the act, amendment to the act is justified by these reasons. Here there is a public demand, very well. But public demand is not for removing them. Public demand is to take action against them. So there is no link, there is no justification for the action taken. Public demand is all right, and your duty to respond to the public demand is also all right. That I am not disputing. What I am saying is that you have not acted in accordance with the demand. You have acted according to the pressure, and you have taken some action for which there is no justification. And lastly, my lord, about K.M. Srivastava's case. Well, K.M. Srivastava's case, he was not qualified, number one. And number two, the initial stay was granted so as to stop the oath taking, because under the Constitution, my lord, Article 219 says for a High Court judge, administration of oath is necessary. But in our case, it is not necessary. It is by regulation. and regulation you have brought by in exercise of power under 318, which says the rules, government has power to make rules for regulating the service conditions. And that is why it's not imperative, it is not necessary. And lastly, my lord, oath taking is maybe a formality for the honorable judges of the High Court after they are appointed, but for the members of a commission, oath taking is not at all a formality under the Constitution. It is by a regulation, and Lordship will kindly see in the appointment letter it is mentioned that your term of 6 years will run from this date. They have given a date, and that is the date of oath taking. Had they not given this date at this observation in the appointment, it would have been an appointment from the day one. And a counting will take place. 6 years will be counted from day one. They have just for the purpose of giving the date, because when he will start working after oath is taken. But this will not give you a handle to say that, see, since oath has not been administered, I have a power to recall. No. Oath is a formality which is a natural consequence. You have to just follow it. You have to do it. By not doing, you do not get the handle to recall the order. Because order by itself does not remain incomplete but for this oath taking. Because there is no mention in the Constitution that without oath, he doesn't become a member. That's all.
Yes, fine.
Two quick clarifications, my lord, factual clarification. Firstly, first submission that was made was that the public demand was for recall of some officials. Actually, it is not correct. Your lordship will kindly come to Rosita Bar petition. Page 213. WBC 213. Page 90 is the meeting held with the stakeholders in the Honorable Chief Minister's Conference Hall. And your lordship will kindly come to page 93. This is reduced in the form of a resolution.
Cancellation of order.
Yes. So factually it is not correct. Yeah. So the public demand, when it came to these petitioners, this is the public demand.
Present chairman.
Present chairman and members of the so-and-so was agreed. Cancellation. Now, so far as the other argument that has been advanced, that Citizenship Act is a consequence of Sarvananda Sonowal, that is not correct. Citizenship Amendment came in 1985 and Sarvananda Sonowal came in 2006.
Sarvananda is IMDT.
IMDT, but when did it come?
6A came after
agitation. 1985.
It's all right, my lord. 6A subsequently it was found that there was threat to the internal security and external aggression. But then 6A was amended because of this. This is what I'm saying. And my lord, this regarding
this, want to say background facts of Sarvananda Sonowal even remains when the act memorandum was signed.
Yes. Yes.
Yes, Pagi.
Yes. Just one line. I said I'll just refer to one line of Royappa. That line is, I missed that. It says they require paragraph 85. Same paragraph. I mean, I said I'll rely on only one line. They require that state action must be based on valid, relevant principles applicable alike to all similarly situated, and it must not be guided by any extraneous or irrelevant considerations, because that would be denial of equity, where the operative reason for the state action as distinguished from the motive inducing from and outside the area, inducing from the antechamber of the mind, it is not legitimate and relevant, but it is extraneous and outside the area of permissible consideration. This is what has happened here. In your mind, you are thinking that these person, they are asking for removal of this person, assuming that there was a demand for removal also. In your mind, you are thinking that they should be removed. But for removal, when you know what are the valid reasons on which a person can be removed. I said there are 3 counts. If I obtained the appointment by fraud or misrepresentation, or if I am not qualified, or if there was no selection through which I have been appointed, then you can withdraw. Other than this, it will be an arbitrary action because you cannot justify the action. They may demand. People may come with very many demands. But when you as a state, you take action, Supreme Court says you have to follow Article 14. People should not comply with Article 14. But you are taking an action, you must comply with Article 14. And it says in your mind, it may be there that there is a demand to remove this person. Assuming that there is a demand for removing this person is there, then you have to justify this. How can you justify a removal? Unless you say that these persons are not qualified, this person has obtained the appointment by fraud, or this person's selection did not take place. How can they be appointed? Other than this, it's going to be arbitrary because it will be an irrelevant consideration. They may demand, but you as a state, you cannot succumb to that kind of thing. That is my suggestion.
Yes, fine.
I'm sorry for taking this petition.
All are excused. You can go.
What has been now argued, I will not reply on 317 and 317. Senior has already argued on that. What has been sought to be argued orally is that there has been some mass movement in the state because of this, and the public demand was accepted, and that is how these impugn actions were taken. So as if there was some mass movement all over the state and all this. Now these things, and it was also argued that this organization said they should be removed. They have lost public confidence. I did not submit a single document showing that this organization supported me. Now, these are not pleaded cases. I could have replied to that. I could have said Congress party supported me. The All Arunachal Students Union supported me. But these are not pleaded cases, madam. So I could not reply to that. In fact, if this were pleaded, I would have filed a reply to show the so-called stakeholders who went after that.
No, there was a movement, and they, on the basis of the negotiations with the leaders, and movement was there, thousands of people gathered on that. You say it to be a pressure, and they say it to be a democratic system. So these facts, there is no dispute.
My lord, on that there are disputes, my lord, because this is not their previous case. They have accepted that what I have said is they have created law and order situation. That is how you succumb. That is what I have said. Now the argument being advanced is,
according to you, they have succumbed to this situation, creation of public policies and public demands and all. You succumb to this demand to avoid certain things, the coming of the president, and you made me scapegoat. There is nothing against me. And according to them, no, we applied our mind. There is a demand from the public. We had a negotiation, and we have the power to recall in the public interest. This is, according to this cannot be a public interest, because this is nothing but succumbing to the movement of some people, and that will not give you a right to remove me from that particular post, one appointed and selected, until and unless I have, you can prima facie show that there is a fraud, there is a non-qualification, and third is three situations, not even selection. Otherwise, there is no nexus between demand and removal from the post. Even if they demand, you cannot do. This is you have come to a pressure. They said no. We are a democratically elected government. The government is to be run by the demand of the people, and therefore we are within our jurisdiction and competence to recall the order if in the public interest we deem it to do so.
That part has not been pleaded. That is what I was submitting.
Okay, you want to say that they are having the power. That's why that part is not pleaded.
They have not pleaded just because of public demand and all these things. We have done that. That is not a pleaded case. All these submissions that I did not show any documents to show that this organization supported.
No, that part is not relevant because since they are saying that yes, we have done it in the public interest. Do you want to say that they have not nowhere disclosed it that we have done it in the public interest?
Absolutely, my lord.
But they have said somewhere.
They have only said something in paragraph 16, my lord.
Paragraph 16,
My lord will have by pleading from paragraph 19, my lord. From 19 to 25.
Your?
Yes, 19 to 25, my lord. From the affidavit and my pleading, it is clearly revealed because of a law and order situation created, not public demand, law and order situation created,
Okay.
they have succumbed. And one more thing, my lord. This talk about the stakeholders, my lord. If your lordship may kindly page 80 for a moment, I will not take much time. No, sorry, not 80. Page 90 first.
Page
90.
19
Yes.
of
9 of my petition. 90, man.
90. Yes.
This was the initial demand they were accepted. In fact, my learned senior friend is correct in saying that there was no demand for our removal. Because initially 13-point demand was put forward that I have stated in paragraph 18, my lord. My lord will see at page 93. 13 ends, and this is a further decision that has been taken. I have pleaded, my lord, once they postponed our oath-taking ceremony, they became emboldened and demanded our ouster also. It's our pleaded case. They have said no comments. This is in addition. There was a 13-point demand by the All Nisi Students Union. And my lord, these people cannot be stakeholders. Arunachal has 26 major tribes, more than 125 tribes, sub-tribes. Who are these people, my lord? Only one student organization is here. That's it. Another is this other persons your lordship see at page 93, the Secretary AR and the President Ansu. All these persons, my lord, that's what I was saying. If all these things were pleaded, I would have filed a reply showing that this person, the chairman PAJSC, this other person that on the right hand side, this person below, they were all booked under the EPUAPA, the government manner. And on the next page, there are 7 more persons, my lord. They were put behind bars.
Okay.
And my lord, replying to that was the 18th, the decision was taken, and they have deliberated on only on 29th. My lord, we see the record. There will be nothing there, my lord. In fact, they set over it. These 18-point demands they accepted. They set over that also. Consequent to that, they started protesting. They were put under the EPUAPA Act, and this has been taken. These are not pleaded, so I could not file a reply to that.
Okay. Hearing concluded, judgment reserved.
Just one aspect, my lord, which I had overlooked. The lordship will also not lose sight of the fact that it is still open to them to apply under the new advertisement.
Okay.
If your lordship so desires, we have the records.
How can they apply?
They can. We have not.
Because
We have not.
If they can apply, you can continue with them.
No, if your lordship so.
Item number 2.
Well, if your lordship
desires the records.
I'll have.
Well, just one more thing. That argument.
7 is also separate.
अपने record याद करके ले लेना।
7 is also you make it adjunct.
My lord, just one more. The argument that we had lost the confidence of the public, these are not pleaded cases, man. My lord knows this has to be pleaded. These things. We would have replied to them. That is in fact incorrect also.
His paragraph 21 shows that he has lost.
My paragraph 21 only shows only shows that there is
We'll go ahead
a situation
on this
created.
pleadings.
My lord, I need 19 to 25, my lord, paragraphs. Of my
19, I have wrote,
Yes,
right. But what about that note? Have you got this earlier findings note? Where is it kept?
It must be this.
No, his written argument is there. I have written in the note his argument. Thank God that I have written in his note of argument that is with me personally.
And we have all submitted, I think, Mr.
Everybody
We
submitted.
we have all submitted.
Yes, yes, that earlier argument and subsequently I have two copies. In fact, one I brought with me for this Diwali bus. Two sets.
Deep level.
Any,
Deep down.
All right.